Thank you for the introduction.
Thank you very much, Mr. Pukula. I would like to then move on and introduce Ms. Zandile Mpungose, who is the Deputy Chairperson of the Energy Regulator and the member of the Piped Gas Subcommittee. Ms. Mpungose.
Good morning, Chairperson, and good morning, everyone. And thank you for the introduction.
Thank you very much. Mr. Meiran, if you can kindly switch off your video and mute yourself. Thank you very much. Members, I want to go on to introduce my other colleague in this hearing, which is Ms. Musuvukile Mkhize, who is the member, full-time regulator member, primarily responsible for regulating the petroleum pipelines, and he is also the member of the Pipe Gas Subcommittee. Mr. Mus Mkhize.
Thank you very much, Chairperson. Greetings to you and everyone in this public hearing. Thank you.
Thank you very much. I would like now to introduce my colleague, Mr. Nhlanhla Gumede, who is the member primarily responsible for regulation of electricity, and he is also the member of the Public Gas Subcommittee.
Good morning, Chairperson. Good morning, members. Thanks.
Thank you very much. Mr. Dlamini, I'm not sure if we do have the CEO with us today, but if he's not there, I can introduce her at the stage when she joins the hearing. But I would like to proceed at this point in time to then read out the proceedings of all the rules of today's proceedings. I would like to indicate that this hearing today was duly advertised as required by the Pipe Gas legislation. It was advertised in various newspapers, including the Bielt Sunday Times, as well as Independent newspaper on the 24th of March 2024. It was also posted in the NERSA website. And the hearing today is held in accordance with the Energy Regulator Act of 2004. And that act does require us to afford the affected parties an opportunity to submit their views and present the relevant facts and evidence to the Energy Regulator so that the Energy Regulator can be assisted in arriving at the right decision. And today's hearing, it is also governed by the rules, the NERSA rules, on public hearings, and I will summarize some of those rules that we need to observe today in these proceedings. We want to apprise the parties that, or the audience and everyone, that it's only parties that requested to make presentations, that such presentations will be made under oath, and also that this public hearing is the public hearing set down for the hearing of the application by Sasol Gas. Each party that has requested to make presentations today is allocated 30 minutes to make their presentation. So we will look into the aspect of time, and if the parties wish to sort of exceed this time that we set, the parties must inform us so that we can decide how much time we can add on the original time that has been set or allocated to them. Only the members of the panel may ask questions to the presenters, but if there is any member of the public that wishes to get clarification or put forward a question, they must submit that question to eliezer.dlamini@nersa.org.za. Mr. Dlamini will also put this email address on the chat so that it is easier for them, for the audience to see it and submit their views to Mr. Eliezer. Then Mr. Eliezer will then forward the question to the members, and members will decide how to pose that question or clarify the issue that is raised by the member of the public. Should the presenters that have requested to make their presentations today be of the view that some of the information that they need to present contains confidential information, they need to inform the members of the panel, and the panel will then decide on whether or not to hear that information. Should they decide to hear that information, they will therefore clear the room and also only the members of the energy regulator and their staff that will then be in a position to hear that confidential information. I would like to also just inform the members of the public that today's hearing is recorded, and it is recorded also live in terms of the NERSA Twitter page, and that such recording will be the official record of this meeting. Just the House rules, so that we make sure that the hearing is not interrupted. We would request you to please switch your cell phone to silent mode. And please make sure that the mic and the videos are switched off at all times, unless you are making a presentation. Please use the chat responsibly to contribute to a meaningful discussion through the public hearing. And we will not consider statements that are on the chat. As I indicated, anything that you would like to bring to the attention of the panel and that you want the panel to clarify, please send that to Mr. Eliezer Dlamini, then we'll consider it. In terms of the parties that requested presentation today, we have Sasol that is going to do the presentation first as the applicant in this matter, and we have Mr. Rudy Histerman, as well as it's Dr. Pindile Masangane from Sasol that are going to start with their presentation. We also have Mr. Peter Smith from SLG Pty Ltd, who's also going to make a presentation. And lastly, we also have a request from IGWASA, and we have the CEO of IGWASA, which is Mr. Yako Human, who is also going to lead the presentation for IGWASA. And I would like now to go straight to Sasol to ask them to take the oath. Sasol Gas, must we do it for both Rudy as well as Dr. Masangane? Is just the two of you?
Good morning, Chair. Good morning to the committee members, and good morning to everyone. Actually, there is 4 of us, Chair, from Sasol Gas. The presentation will be made by myself and Mr. Menkes, but I ask that you swear everyone in so that the questions can run smoothly, if that's okay with you.
All right. Thank you very much. Yes, let me start off then with Dr. Masangane, if I can start with you. Okay, may you, do you have any objections in taking the oath?
I have no objections, Chair.
All right, thank you. May you please raise your right hand? Do you solemnly declare that the information you're going to provide to this panel today is the truth and the whole truth?
Yes, sir. Yes, Chair, I confirm that.
Thank you very much. May you please state your full name as well as your designation at Sasol?
I am Pindile Masangane. I'm the Vice President for Regulation and Policy at Sasol.
All right, thank you very much. May we then go to Mr. Menkes? Okay.
Good morning, Madam Chair.
Thank you, Mr. Menkes. Waiting to see you. All right. Mr. Menkes, do you have any objection in taking the oath?
I don't have an objection to take the oath, Madam Chair.
Thank you very much. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you are going to present before this panel today will be the truth and the whole truth?
I confirm.
Thank you very much. Please state your full names as well as your designation at Sasol for the record.
My name is JP Menkes, and my position at Sasol is Vice President Legal Services for the energy business.
Thank you very much. May we please go to Rudy Histerman?
Morning, Chair. Morning, all the participants.
Okay.
Camera went off. There you go. Sorry.
All right. Thank you very much. Do you have any objections to take the oath?
No, I do not, Madam Chair.
All right. Thank you. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you are going to provide to this panel today will be the truth and the whole truth?
I do.
Thank you very much. May you please state your name and your designation at Sasol for the record?
My name is Rudy Histerman, and I'm the head of regulation for energy markets.
All right, thank you. I'm not sure who the 4th person is. For Sasol?
It's Corneille de Beer, Madam Chair.
Okay. All right, Mr. Beer, do you have any objections in taking the oath? You are muted, ma'am.
No, Madam Chair.
All right. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you're going to provide before this panel today will be the truth and the whole truth?
I do, Madam Chair.
Thank you very much. Please state your name and your designation at Sasol.
I'm Corneille de Beer and I'm Manager Regulatory Reporting.
All right, thank you very much. Sasol, if you can kindly start with your presentation, we are going to give you 30 minutes to start, do your presentation. Thank you.
Chairperson, let me start by thanking your committee for granting us the opportunity to once again summarize what our application is about. In terms of presentation, I'll just take the first 2 slides and I'll request my colleague, Mr. Menkes, to take the rest of the presentation. Next slide, JP. Chairperson, we'll start off just by indicating the background, which I think we all know what it is, and then we will summarize what the submission is about, or the application is about, and then we will request for the specific approvals that we are requesting for. So JP will summarize what those approvals are. You will recall that under the 2020 methodology, which was a hub price benchmarking methodology, the regulator approved an FY22 maximum price for maximum gas price for Sasol Gas to use in charging its customers in the market. What subsequently happened, Chairperson, we had geopolitical events that significantly increased those hub prices. Consequently, then our FY23 maximum gas price, if one were to apply the same methodology, was going to be really a 4 times multiplier of the FY22 price. Consequently, then the regulator requested that we should not implement that FY23 price, which was coming out of the hub price methodology, but rather we should continue using the FY22 price until this issue is resolved. So, Chairperson, you will know that our price of gas acquisition is indexed by some of those prices. We then suffered very, very significant price increases in terms of our cost of gas acquisition when we moved from FY22 to FY23. Yet that increase we could not factor in that price. We had as much as 18.61 rand per gigajoule of price increase, which you would accept that this price was outside our control, and it was a prudent price that we had to incur in order for us to continue supplying gas to the market. In October last year, the regulator then made a decision that for us to rectify this very significant cost that we had suffered, the only way out of it was for us to bring forward an FY23 clawback application. It's in this context, Chair, that we are bringing this application. We also made a conscious decision as Sasol that we will keep our FY23 clawback application separate from our FY25 maximum gas price application, though our request is that the two should run concurrently. This application, Chairperson, we could only make it in December because that's the time when we had our audited financial statement, because a clawback application has to be supported by audited financial statements. So when we had those audited financial statements, Chairperson, we then provided, or we then submitted this FY23 clawback application. And as I indicate, it is based on the audited financial statements, where we've shown the regulator that our cost of gas acquisition significantly increased. We also had an increase in terms of our trading cost, Chairperson. So you will see on this last slide, what is this total clawback that we are requesting for from the regulator. JP, please take the regulator members through the rest of the presentation. Thank you, Chair.
Thank you very much.
Right, thank you, Madam Chair. As Dr. Mazangani indicated, I think if one looks at the background, and again, most of the people in the hearing as well as on the call is well aware of this background, so I'm going to be fast in just refreshing our memories about exactly how we got to where we are before going then into the particular elements of the application that's before the regulator. So for a long time, I mean 15 years or more, there has been an ongoing debate about the most appropriate way in which a maximum gas price is to be set in this market where there's inadequate competition, as is referred to in section 21(1)(p) of the Gas Act. However, maybe luckily for all of us today, we're not part of that particular debate, and we're not dealing with the complex matters relating to that. The application that's currently before NERSA is an application where the regulator is called upon to approve the recovery by the licensed trader of an actual cost increase that took place between FY22 and FY23 in accordance with the clawback mechanism that's provided for in the regulatory framework. And in that period of time, as Dr. Mazangani indicated, we found ourselves as a trader in the situation that the adjustment that was provided for the maximum price in the 2021 maximum price approval by NERSA, we were not in a position to implement that. And notwithstanding the fact that the maximum price over that period was then kept at the same level, as a result of the same macroeconomic drivers that Dr. Mazangani referred to, we were also faced with a cost increase in both the acquisition cost of the gas as well as the trading cost that is provided for in the methodology. Well, even before the commencement of FY23, Sasol recognized the problem with the maximum price in 2023, and in May 22, it already approached the regulator with a possible addressing of that problem through the rationality test mechanism that is provided for in the 2020 maximum price methodology. Subsequently, when that solution wasn't acceptable, there was further engagement between ourselves and the regulator, and the guidance at the end of FY22 was to approach the regulator with a revised price application, which was then duly submitted to the regulator in March 2023. And in October last year, NERSA then handed down a decision in which it decided that that application is not a legally competent way in which to resolve the problem. However, in that decision and the reasons for the decision that NERSA handed down at that time, the regulator then pointed out that on the one hand, the regulator acknowledges and recognizes the price increases or the cost increases that Sasol as a licensed trader was exposed to, and it also then indicated that the appropriate way to resolve that matter is through a clawback application. So I think the next point that I want to deal with, Madam Chair, is just the framework and the basis which provides for the clawback application to be put before the regulator, and the context of the authority and the jurisdiction of the regulator then to indeed approve the application that that Sasol Gas has put before you. So as we all know, the regulation of price is provided for in sections 4 and section 21(1)(p) of the Gas Act, together with the provisions of the pipe gas regulations, and then also the methodologies, and in this case specifically the 2020 maximum gas price methodology, together with a tariff guideline to which that methodology refers. I would like to draw your attention then specifically also to the provisions of Regulation 4.4, which specifically provides that in setting the maximum prices, the prices that NERSA approves have to enable the licensee to recover, on the one hand, prudently incurred cost, and then also a profit commensurate with the risk. Now, as Dr. Masangani has indicated in the opening remark, NERSA, through the 2021 maximum gas price decision and the adjustment that was provided in that decision for the maximum gas price, approved then a maximum gas price for FY22 in the amount of R68.39. Now that price, being a maximum price approved by the regulator, then complies with and answers the requirements of Regulation 4.4 and enabled in FY22 the licensee to recover the prudently incurred cost through the acquisition cost and the trading cost of the licensee, as well as a profit as well. However, through the direction that the regulator gave, that very same price should continue to apply in FY 2023, while the adjustment that was provided for in the 2021 maximum price decision of NERSA was not allowed to be implemented by Sasol Gas. We find ourselves in a situation that the FY22 maximum price applied in FY 2023 does not enable or does not adhere to the requirements of Regulation 4.4. I've already alluded to the attempts that was previously made in order to try and resolve the FY23 price conundrum that Sasol Gas found itself in, and in the October 2023 decision, NERSA then specifically pointed to the fact that the appropriate solution lies in the clawback mechanism, which is the basis for the application that is before the regulator today. Now, that clawback mechanism is a recognized regulatory mechanism to deal with changes in the cost base occurring in comparison to the basis on which a price or a tariff was applied, and in a subsequent period, if an unforeseen change then takes place. In the case of NERSA specifically, as the sector-specific and price regulator in relation to the gas business in South Africa, this mechanism finds application in the tariff methodology, and then specifically in the 2020 maximum gas price methodology in section 5, the methodology refers to the tariff methodology and points the licensee and the applicant to the guidelines for clawback and clawback applications that set out in that tariff methodology. In addition to that, earlier this year, the regulator also published a clawback clarification note, and we submit that the application that Sasol Gas have submitted complies with the guidelines in the methodology, the tariff guidelines, as well as that clarification note. As we've pointed out in the previous decision that the NERSA handed down in October, the regulator also specifically advised the licensee that in order to cater for the cost increase that was not previously catered for in FY 2023, the appropriate way to approach and resolve that problem is through the clawback mechanism, which NERSA in that decision describes as a legally sound approach. And it's on that basis that the application is then before the regulator. So let me just go to the next page. So specifically then in paragraph 7.55 of that reasons for decision, the advice to Sasol Gas is set out, and then subsequently when the FY24 maximum price was approved for Sasol Gas, that price is currently under implementation. NERSA also clarified that when it comes to clawback decisions, that one has the option to either include that in the maximum price application for the subsequent period, or it can be dealt with as a standalone application. Now, Sasol Gas admits that the clawback application, which we've submitted to the regulator in parallel to the FY25 maximum gas price application, and the purpose of doing it in parallel is for transparency so that the regulator as well as the affected customers are well aware of both the maximum gas price implication as well as the clawback implication at the same time, even though the two applications are brought as a separate application. The other reasons why we ultimately opted for bringing the application as a standalone application is that the particular maximum gas price methodologies adopted by NERSA for the two different periods are different from each other. The FY23 period is subject to the 2020 price methodology, and the FY25 maximum price application is naturally subject to the 2023 maximum price methodology that was adopted by NERSA. It is, however, important to note that both these methodologies refer to the clawback mechanism through its reference to the tariff methodologies. In the 2020 price methodology, that is section 5 of the methodology, and in the 2023 methodology, that cross-reference to the tariff guideline is in section 6 of the methodology. We also thought it prudent that the controversy and the issues surrounding the FY23 time period, which was the last year of the 2021 maximum gas price decision by NERSA, should not be linked to the FY25 maximum price application, and that the issues around that particular period is best dealt with in a bespoke application, and that is the reason why ultimately we opted to bring this maximum or this clawback application as a separate application. The intention is going forward, and as the price methodology remains the same, that one would then possibly in future, if clawbacks are required, try and incorporate that into the maximum price applications in the future. So that's the background to the application. Just in summary, what the applicant is putting before NERSA and requesting NERSA to approve consists of 3 elements. The first element is, and that is also what Dr. Masangane referred to, is the actual change in the weighted average acquisition cost as it applied in FY22 compared to how it applied in FY23. And the mathematical calculation of the difference between the weighted average acquisition cost in that 2 years comes to 18.61 rand per gigajoule. The second component is the change in the trading cost. The trading cost, and in my next slide, I will indicate that trading cost is calculated in accordance with the guidelines and the formula as set out in the applicable methodology. And the difference between the trading cost in FY22 and FY23 amounts, according to Sasol Gas's calculation, to 72 cents per gigajoule. And then the guidelines for clawback also provides for the time value of money. And as this cost increase already started at the start of FY23, but we find ourselves in a situation that this clawback will only be implemented from the start of FY25, there is quite a considerable time delay, and therefore it is reasonable and prudent for the regulator also to approve that the time value of money be taken into account as it is provided for in the guidelines for a clawback as set out in the methodology and the guidelines. And that third component we calculated based on the change in the inflation rate as being 96 cents per gigajoule. And therefore the two elements combined, or the three elements combined, we are requesting the regulator to approve a clawback in respect of the FY23 period of 20.29 rand per gigajoule. And the intention is that once that is approved, that we will implement that over a 12-month period as a separate line in the interest of transparency on the invoices to customers. The 12-month period that we propose for the recovery of this clawback is to align the recovery to the same period or the same length of period within which the cost increase occurred originally. But secondly, also, we think it's in the interest of both the supplier and the customer to confine this recovery to such a 12-month period so that we don't end up in a situation where multiple clawbacks are then basically recovered from the customer in different periods. So we basically want to resolve this one within that 12-month period, and if any future clawbacks may be required, that they are dealt with distinct from each other. I think lastly, Madam Chair, I just want to highlight the basis on which the application was prepared. As I indicated, the first element deals with the change and the increase in the weighted average acquisition cost between FY22 and FY23. For purposes of this calculation, we took into account the acquisition cost of the natural gas imported from Mozambique. The basis of that price is obviously part of the license conditions that the gas producers have in Mozambique. And the movement in those prices are linked to international oil derivatives, and there is also a component of inflation indexation relating to the operation of the processing facility. As far as the methane-rich gas is concerned, the price adjustment drivers in that case includes the South African producer PPI, and then also Dubai oil. And then as a result of the link to the Dubai oil price, there is also an exchange rate element. And based on the calculations of the actual audited prices that applied and this acquisition cost that applied over the period in time, the clawback of 18.61 rand per gigajoule was calculated. In the consultation document, NASA indicated that when they performed similar calculations, they confirmed and basically got the same figures as calculated by the applicant. The second element is then the calculation of the trading cost. And again, the trading cost calculated in accordance with the formula prescribed in the methodology was utilized. And then that calculation was done based again on the actual audited figures that is contained in the audited the regulatory financial reports as submitted to NERSA. That is the data on which the calculation was done. And in comparing then the two trading cost figures between FY22 and FY23, that difference of 72 cents per gigajoule is derived from that calculation. In the consultation document that NASA published after reviewing the application by Sasol Gas, one of the points where there is a difference of opinion between ourselves and the regulator is the inclusion of the cost for unaccounted for gas. This is an actual cost suffered by the applicant. It is a cost that arises through the transportation of gas through the pipeline network. It occurs downstream of the actual supply of the gas by the producers. But Sasol is comfortable with restricting the extent of that cost to the 1% unaccounted for gas calculation that NASA previously utilized in the approval of the maximum price for FY24. So I just wanted to clarify that is a point where there is a difference of opinion, but in our written submissions in response to the consultation document, we have pointed out and supported and substantiated that the calculation is done based on the formula in the methodology, and we also submitted the explanation around the unaccounted for gas point that I've highlighted, Madam Chair. So that basically brings us to the point where we, as an applicant, is standing before the regulator today, and we are asking for the approval in accordance with the application that we made, and that application is submitted from our side to comply with the guidelines that's contained in the 2020 maximum gas price methodology, read with the 2017 tariff guideline to which that methodology refers, as well as the clawback clarification note that was published earlier, and then earlier this year by NERSA, and then very specifically also in accordance with the recommendation that NERSA made as part of the reasons for decision in its 26 October 2023 decision. And we therefore ask the regulator to approve the clawback of R20.29 per gigajoule in order to enable the applicant to recover these prudently incurred costs. And then secondly, we are also asking the regulator to allow that clawback to be done over a 12-month period immediately following the approval of the application by the applicant. We are hopeful that a decision in this regard will still be taken by the regulator to enable us to implement this clawback in parallel with the maximum gas price for FY25, so that this clawback as well as the maximum gas price for 2025 will then basically be applied and implemented during FY 2025. So, Madam Chair, that's where I will end the presentation. Dr. Masangane, I can hand back to you if there's any closing remark that you want to do before we move to questions.
None, JP. Thank you very much. Over to you, Chairperson.
All right, thank you very much. I think you've saved about 4 minutes in terms of the 30 minutes that we have allocated. Thank you very much for saving us that time. If you can kindly have a piece of paper and a pen so that you can take down the questions that may come from the members. Members, I would like to invite you to ask questions of clarity from the presentation that we received from Sasol Gas. By show of hands, members, if you have any questions. Let me start with Mr. Mkiza. Mr. Mkiza, please go ahead.
Thank you very much, Chairperson, and thanks to Masanani and the team. From my side, I think the presentation was pretty clear. Just got one issue to seek clarification on. As to how does Sasol in this case see the trickling effect of their cost, which they are saying that has been prudently incurred? How do they see that to downstream from their side? Or how did it affect its customers and downstream, so that there is equitable treatment throughout the value chain? It could be that maybe they also in that process were able to get some benefits because they are not the end user at the end of the day, and therefore that clarification. As far as they can, they understand from their side. That's all, really. Thank you.
Thank you very much, Mr. Mkize. I do have some questions of clarity also from my side. I would like to start off with the question pertaining to Sasol's request that NERSA considers a time value of money for this application. My first question on that is, what is the legal basis for the time value of money if Sasol can point out from the maximum price methodology, if the maximum price methodology allows for time value of money? And if so, on what basis should that be considered? And also, especially if customers are not to be held responsible for Sasol not implementing a reasonable adjustment when they were allowed to adjust. So why would customers then be required to pay much more when they cannot be held accountable for the non-implementation of that price? Those are the two questions. If you could answer those questions, the legal basis for it, where in the methodology, as well as why should then customers be required to pay for that? So that is the second thing, the first thing. And then the other question that I would like Sasol to clarify pertains to unaccounted for gas. The issue of the unaccounted for gas, how do we take that into consideration if in terms of the methodology, we have never mentioned that aspect in particular of the unaccounted for gas? That's the first thing from a legal basis. But also, then what will be the incentive here? Because if this has to do with the losses that occur in the pipeline, and in this case we are dealing with the molecule, not necessarily the service or the assets. So if this is something that occurs during the transportation of gas, is it something that should be claimed from the cost of the molecule? Or should it be something that is claimed from the cost of the service that is provided? Why should it be included here and not then in the cost of the service when gas is transported? And also in terms of the incentive, how can the regulator be in a position to make sure that we can minimize, such losses, and also be able to measure then the gas that gets delivered in Secunda all the way from Mozambique through the Romco pipeline. If the losses, for instance, they get to 3% or so, and this is the pipeline that is operated by Sasol, and it's a Romco pipeline. So how do we then make sure that we can get efficiencies in the transportation of the gas? If then we're going to say that we will compensate Sasol, should there be these losses that are accounted for? How do we make sure that this will be done in a manner that is efficient? If that can be clarified by Sasol Gas. The last point that I would like to just clarify so that there's clear legal basis for the clawback. If you can just also point out, I know that you did touch on this in terms of Regulation 4.4. Is there any other provision that you would like to assure the energy regulator that it has powers to consider a clawback to the extent that the licensee has under-recovered its cost, and therefore it is therefore entitled to then apply to the energy regulator using the audited financials? Where else can we look into this apart just from the interpretation of Regulation 4.4? Those are the questions for now. Thank you very much. I will check other questions that may have been posed by the members of the public.
Thank you very much, Chairperson. I'll take the first question around the price impact to customers and how we can, how as Sasol Gas, our view in terms of sharing that pain, if I may call it. And then I'll ask Rudy next to me to take for the question on the unaccounted for gas. And then I'll leave the three legal questions to Mr. Menkes to handle, if that's okay with you, JP. Excellent. Chairperson, I think there is no one here who disputes the fact that these costs were unavoidable, that they were outside anyone's control when the geopolitical things happened globally, and it escalated or caused the hub prices to skyrocket. So the question that I'm hearing Mr. Mkhize asking is, how do we make sure that this pain or this predicament and the cost therefore is equitably shared? In my view, Chairperson, that pain or that misery is already equitably shared, because what we are asking for as Sasol is not to recover the cost and to do the actual benchmark as the 2020 methodology would have allowed us to, because as I indicated, that price would have come to over 250 rands per gigajoule. But rather what we are saying is that to make sure that this is fair and equitable, allow Sasol Gas, Mr. Mkhize, to allow the cost, the direct cost, the actual cost that each cost of gas acquisition increased by. So we believe that is a fair and equitable way in which this cost can be recovered, because Sasol Gas did incur this actual increase. So we suffered a lot of financial prejudice when this global prices increased. But what we are asking for is that can we recover the costs that were directly applicable to us using the international benchmarks that are used in our pricing between our suppliers and ourselves. Rudy, if you can please take the question on the unaccounted for gas.
Madam Chair, thank you. I think unaccounted for gas and the question you ask is very good. I think there's a contractual background to it. Unaccounted for gas up to a level of 2% for the account of the owner of the gas, in other words, the shipper of the gas. So it's only when it goes above 2% that the transporter of the gas becomes responsible for that cost. And I think we all have a reasonably good idea of how small a molecule methane is. So there are unavoidable losses, and there also meters are pretty much they're mechanical. They're mechanical devices, so absolute perfection in measuring doesn't exist. So contractually we have a 2% limit, and by the regulator limiting Sasol Gas to 1%, obviously then, which means that we Sasol Gas or any other licensee for that matter would carry the losses that are incurred above 1%, provides an incentive for the trader then to work with the transporter to ensure that those losses are limited and they don't run away. So it's a natural, if I might call it that, a natural efficiency factor that gets built into the relationship between the trader and the transporter. Then I hope that answers the question, and I'll hand over to JP. But JP, you may just want to add a little bit to the unaccounted for gas as well.
I think, Madam Chair, as Rudy suggested, I think maybe on the unaccounted for gas one, there's two points maybe to add. The one is that it is a generally occurring phenomenon within pipeline systems, the fact that there is unaccounted for gas. Obviously, there is a obligation on the owner and the operator of the pipelines to minimize that as far as possible. But to the extent that the unaccounted for gas occurs, it is a actual cost that is suffered by the owner of the molecule, and then sharing that risk ultimately becomes a contractual matter. And as Rudy has indicated, the exposure that the gas trader in this particular instance has is basically double the level that the regulator is proposing, that the unaccounted for gas should be included in the calculation. The question about whether unaccounted for gas is mentioned as a particular item in the methodology or in the guidelines relating to the trading cost and the calculation of the trading cost, not each and every operational expense is mentioned particularly, but the fact remains that it is a cost that forms part of the network and the value chain that we are dealing with. I think the other two questions that I just want to deal with is the question that you asked about the time value of money and the ground for that. As I indicated, the calculation of the clawback is provided for in the methodology through the reference to the tariff guideline. And in the tariff guideline, when it comes to the calculation and the implementation of the clawback, there is a particular provision in the tariff guidelines that provides that the time value of money is to be catered for, and it's on that basis that we, as an applicant, included that in our application as well. When it comes to the legal basis for the clawback application as such, as we've indicated, the fact that Regulation 4.4 very specifically requires that the price regulation should be done in such a case that, or in such a manner that the reasonably incurred costs by the licensee is catered for is fundamental in this regard. But if one steps back then into the Gas Act and the objects and intention of the Act in regulating the price in order to ensure a proper development of the market, and also taking into account the interests not only of the customers but of the suppliers as well, then obviously within that context, the catering for this particular situation through the clawback mechanism that is recognized in the methodology and the tariff guidelines to which we refer is actually an appropriate mechanism to solve the problem. I think within the finding of the Constitutional Court in the consideration by the court of the price regulation by the regulator as well, there is particular a guiding principle that ultimately in managing the price environment, the regulator has to strike a balance between the interests of the supplier and of the customer. And it's against that backdrop that the application is before the regulator. Madam Chair, I think that's the response at this moment.
Okay, thank you very much. We do have questions. I also shared with the members, if members can check the questions. I think there's a number of them so that we can share some of those questions amongst ourselves. If members, you can kindly check. But I just want to first make a follow-up with the team from Sasol. Starting on the issue of that, again, I'm sorry to hammer on the issue of the time value of money, because also it's not sort of an automatic thing in any event, even if it can be provided. That's the first thing. But the second thing is that that issue of the time value of money is only in respect of the tariff guidelines. And the reason why we use tariff guidelines in this application is only for purposes of the trading margin, and of which trading margin is allowed in terms of Regulation 4.4. Therefore, it is not on the component of the charge for the molecule. It is only on the component for the charge for the service, the trading assets. So it's not the entire thing. So I just want that to be clarified, so that it is not something that is claimed with regards to the charge for the molecule, and that's how the Gas Act is. So I just want Sasol to make that to draw that distinction and make that clarification so that we all understand it. There is an issue also of the implementation of the issued NERSA approved the clawback, the implementation that Sasol says it be implemented over 12 months. And stakeholders are a bit concerned about also the implementation should this application be approved. The question is, what happens if the clawback amount is recovered within 6 months from the recovery period as opposed to 12 months? Does Sasol intend to stop clawback recovery? I think that's the question. What if it is not recovered in 12 months? Will Sasol forgo the clawback? I think those are the two questions. I will allow other members to come in. I have Mr. Mkhize, if you can kindly take down the other questions that I've asked. The 6 months, what happens? The 12 months, if it's not recovered, then what happens? Would you forgo it? What is going to happen? If you can just gather your responses there, take it down. Mr. Mkhize, you may please come in.
Thanks, Chairperson. Without necessarily leading a meeting, I would appreciate if at a technical level, maybe there can be a sharing of notes around this whole issue of unaccounted for gas. Because if I look at the 1%, I see it from my side as more of what is already included in the price of the molecules. Like you will have ocean losses if you were to look at the liquid fuels side, where the price is already included in the PFP, those losses are taken in. And then when it's above that, then the argument is whether you've been negligent to an extent that you went above the limit and therefore you don't get compensated. It's a loss that you incur, or you then get some compensation for that because of some strange reason that has happened. So if you can just look at that technical without necessarily responding in the here and now. The issues that have also been raised that maybe I can talk to here is that is it competent to recover acquisition cost using the 2017 tariff methodology? How should other traders go about to recover the clawback amount if Sasol's application is approved? Have you taken into account that consumers might have used less gas if they knew that the price would be 20 rand per gigajoule more, if it had included that? I will. And the other thing is just the validity of the decision that the agreement reached between Sasol and NERSA was transparent. Just to confirm that is all. It's not taken behind closed door. Thank you.
Yeah, you must put it straight, Mr. Mkhize, and not be scared to put it because it did not happen. But let's ask Sasol from his side. The question that is put here, which I think it must be put out there to the public so that they understand exactly what is being asked. The question is asked is this: that was the agreement reached between Sasol and NERSA behind closed doors to keep the price at 68 rands per gigajoule a formal decision of NERSA? In other words, was it a valid decision, or should Sasol rather have taken the decision of NERSA stating that Sasol should keep the price at 68 rands per gigajoule on review? If Sasol can clarify from their side, but we will also just make it clear from our side that we have never taken such a decision that they should not implement. We only had an issue with the extent of increase, and we said that extent of increase is irrational, and therefore it is not even something that is closer to the cost that Sasol would have incurred, and therefore will not allow Sasol to then use that adjustment factor of the decision to then have a sort of a windfall that will be detrimental to customers. I think that was communicated clearly, and it's also in the media statement where we said we will not allow Sasol. So Sasol, you can also just comment from your side about any decision. Otherwise, there's no decision. The decision that is there that can be made available is that we said it is irrational, and also the media statement where we stated that we will not allow Sasol to recover more than what it costs Sasol, and therefore Sasol benefit from the windfall. Thank you.
Thanks, Chair. I think that would be a good segue. So let's start with the legal questions then, JP.
Yeah, I think maybe let's just Madam Chair, clarify. I mean, there's no agreement or any arrangement that was at any point reached or anything like that. There was a decision that NERSA took, which is the 2021 maximum gas price decision. That decision is already under review in the High Court, as you are aware. The situation that we faced, and which I explained in the background to this application, is that that particular decision, which is not overturned until a competent court makes a decision to overturn it, that particular decision included a provision in terms of which there was an approved method for which or on which the price would be adjusted in FY22 and FY23. In FY22, that adjustment took place. It was implemented. It was approved by NERSA, and that is the origin of the 68.39, and that is a price that was implemented with support and in accordance with the existing decision that NERSA took. When it then came to applying the adjustment that is provided for in that decision for FY 2023, as a result of the circumstances that we've described, that adjusted price then yielded a price that was impractical and inappropriate to apply in the market. There then followed a whole series and range of engagements between ourselves, the customers affected, as well as the regulator. And as part of that engagement, there was a directive that was issued, and that is confirmed also in the reasons for decision that was handed down by NERSA on the 26th of October, that there was a directive then issued that while the FY23 price is not resolved, that Sasol should continue to charge the FY22 maximum price. The way that Sasol then endeavored to resolve the matter was to bring an application where we indicated that Sasol was willing to relinquish the maximum price yielded by the 2021 maximum price decision. And we approached NERSA and we requested the approval of a revised price for that period, or a price different to the one that was proposed in that application. In October last year, the regulator dismissed that application. So we ended up in a situation that for the entire period that the price that Sasol Gas was entitled to charge remained at the same level as the maximum price in FY22. The attempts to revise that application through, or that price through an application to NERSA was not agreed with by the regulator, and ultimately there was then guidance provided that this clawback mechanism that is provided for in the guidelines and the methodology to which we've referred is the appropriate way to go forward, and that is on that basis that as soon as the audited financial information became available, because the guidelines are also very clear that the that a clawback application of this nature can only be based on audited information to show the difference between what the basis was on which the decision was originally taken versus the changed facts that actually played out in the period in question. So once that audited information became available, the clawback application was then submitted. But in the meantime, the supplier finds itself in the situation that the time that has elapsed between the point in time when the acquisition cost increased and the time in which or at which the supplier would potentially be able to claw that increase in cost back, there's a 2-year period that has actually lapsed, and in line with the tariff guideline, which is used as the guideline for calculating the clawback that we are requesting, in line with the provisions and the guidelines in there that the time value of money should be compensated as well. That was included in the application. But ultimately, again, as the Constitutional Court has very eloquently pointed out in its decision, the methodologies adopted and the guidelines adopted by the regulator are just that. They are guidelines. And ultimately, when the regulator considers the application that the applicant makes, then obviously the legal framework as provided for in the Act itself and the regulations are paramount, because that is the primary and secondary legislation. And then thirdly, the guidelines and the methodologies are taken into account. And ultimately, in the interest then of balancing the interests of both the supplier and the customers in the market, the regulator then has to take a decision by exercising the discretion that it is clothed with in terms of the establishing legislation. So I think it's important that we just clarify that legal framework. Insofar the recovery period is concerned, the point of the matter is that the changes in cost that forms the basis of the clawback application was incurred and was faced by the supplier for the entire period under to which this application refers. And therefore, if the clawback is allowed for a shorter period than the period over which that incurred cost actually occurred, the applicant will find itself in a situation that it is penalized and left out of pocket, in that an actual cost that it incurred over that period, that it is prevented from recovering that. And we would submit that that is not in accordance with the provisions of Regulation 4.4, which specifically allows or provides that the supplier should be allowed to incur reasonably incurred cost. But yeah, Pandile, can I hand back to you for further comment on that particular question?
Thanks, JP. Chairperson, I think the question around would consumers have used less gas, it is an academic question, but I think that consumers knew the predicament that Sasol Gas was facing. Consumers knew that globally gas prices had significantly increased, and that if one were to use the 2020 methodology, Sasol Gas would have increased its gas price from the 68 rands per gigajoule to 274 rands per gigajoule. But Sasol Gas indicated that this price is not reflective of its increase in underlying cost of gas acquisition. So I think as a supplier in the market, we were transparent that the 274 rands per gigajoule should not apply in the South African context. And Chairperson, it would be unfair for the regulator to then penalize us for not having gone through or taken this matter on legal review. I think there was a general agreement or there was a view that let's try and find an agreement. But as JP has indicated, there were endeavors, including applications of a maximum gas price that would be sensible or that would be commensurate with what Sasol Gas was going through. So one cannot then punish us for that, because those engagements were going on between Sasol Gas and ourselves. And therefore, we think on our part, we acted correctly by applying the FY22 maximum gas price while we were engaging with the regulator to resolve the issue, not even to say that in that time, if we had taken it on legal review, what price then would we have used during that period? Chairperson, the question of implementation over a 12-month period, in my opening remarks, we felt that this was important. And this is the reason, Chairperson. You will recall that in 2023, the regulator then had a new maximum gas price methodology, for which we were supposed to use for our FY24 application. Even that maximum gas price was approved very late and therefore became effective on the second half of FY24. So that means we continued to suffer financial loss even as we entered FY24. And we intend to bring another clawback application for that 6 month, which we could not implement the appropriate cost of gas acquisitions that we were incurring in FY24. So stretching this over a longer period of time, Chairperson, would not be good, both for our customers as well as for ourselves. So we really plead with the regulator that we recover this cost over a 12-month period. But importantly, Chairperson, we plead with the regulator to make this decision before the start of FY25, so that these matters do not drag on and on, even when we've changed methodologies. So that's our plea, Chairperson, that whatever happens, the regulator must make a decision, must make a cut. If there are certain costs that they do not believe that we should recover as Sasol Gas, we will look into that decision, but the regulator has to make a decision because these matters have been dragging on for far too long in our view. And Mr. Mkhize, we will make a written submission around the issues of unaccounted for gas. So we will submit a formal paper to the regulator in relation to that. Thank you. That's okay? Okay. Thanks, Chair. Back to you now.
All right, thank you very much, Sasol. I think you've clarified all the questions that we had and also the questions that were forwarded to us. I don't have any further questions from my side that I have received. I just want to make sure that I don't leave the other members behind. I just want to check. It seems there's probably another question. The question is, there is a crude oil and the rand-dollar exchange component in the molecule price that Sasol suffered the loss on. Was there no hedging applied in the Sasol context for this loss, and why is there no offset for this recovery in the clawback application? I'm not sure if that is understood by Sasol, but the fact that Sasol indicated that, remember, in terms of your acquisition cost, because you are buying from the upstream, right? So the price in the upstream is exposed to international changes that are happening. And one of those, the indexation of that price is in terms of, or it is indexed to the price of oil, right? The crude oil, and it's not unusual in the pricing of gas. So, but what they are saying is that if you take the exchange rate component, as well as this issue of the exposure to crude oil indexation, did Sasol not then apply hedge for such changes that might happen? And so that any losses that happen can then be taken into consideration within the hedging for the changes that are happening in the international market for gas prices.
Thanks, Chair. We understand the question clearly, and I think the question is that if our cost of gas acquisition is being indexed to some of these hub prices, do we not have a hedging that should have protected us? I kindly request, unless JP, you want to take it, that we go back to our CFO to check this, and he's the one who must provide the answer. But as far as we are concerned, when we do the accounts of Sasol Gas, we see this cost being passed through. But I think he is the appropriate person that will be able to answer in terms of our hedging philosophies, the costs thereof, and the applicability thereof, and the conditions under which it must be applied. Thanks. JP, would that be okay for you? JP, you're still on mute? JP, you're on mute?
There we go. No, I think that's the right way to deal with that question. Okay. I don't think, I'm not in a position to answer it off the bat. I don't know.
No problem. We will get back to that question. If you can note it when we give you the opportunity to reply after the other stakeholders have presented as an applicant, you will get an opportunity to reply and on the issues. So if you can also remember just to touch on this question during your reply.
We'll definitely do that, Chair. Thank you very much.
All right, thank you very much. I would like to thank you, Sasol, for your presentation. We now moving on to the next presentation, and the next presentation comes from IGUASA, and we do have the names here that we are given. we have Mr. Yako Human as the CEO of IGWASA. Mr. Yako, I will hand over to you so that you can introduce the team and who's going to participate in terms of the presentation. But let me start first by greeting all of you, and also just to ask if you have any objection in taking the oath.
Madam Chair, thank you very much, and thank you for accommodating us. I don't have an issue taking the oath. Our legal representative, Advocate John Meyring, have his own views on that, which he will explain just now. And then we will also be represented today by our economic team from RBB Economics, Simon Lee. Thank you. Thank you, Chair.
All right. Thank you very much. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you are going to provide before this panel today is the truth and the whole truth?
I do, Madam Chair.
Thank you very much. May you kindly state your name and your designation at IGWASA for the record.
Thank you, Madam Chair. My name is Yako Human. I'm the Executive Officer of the Industrial Gas User Association of Southern Africa.
Okay, thank you very much. Let me go to Simon Lee. Simon, if you can unmute. Do you have any objections in taking the oath?
I do not, Chair.
All right, thank you very much. Do you then, can you raise your right hand? Do you solemnly declare that the evidence is the truth and the whole truth?
Yes, Chair.
All right, may you please state your full names and your designation and your relationship with the applicant, IGWASA.
My name is Simon Lee. I'm an associate principal at RBB Economics, advising IGWASA in this matter, instructed by Norton Rose Fulbright attorneys.
All right, thank you very much. All right, let's then, for the record, go to Advocate Jean Meyring. Advocate, do you have any objections in making affirmations?
Good morning, Chair. Yes, it's been a bit every such occasion that I've indicated, as have the other legal representatives, that it's not appropriate for us to take an oath or make an affirmation simply because we're legal counsel and we, in any case, do not speak to facts or evidence. We make legal submissions of law. So on past occasions, that has been accommodated in this and similar fora under NERSA, that certainly I've never taken an oath, and I am not prepared to take an oath today for those reasons.
All right, we wanted that to come out on the record, that you will confine your submissions to legal argument as opposed to the facts, economic facts or the actual facts that are happening in the market. Thank you very much for that. May I request JP just to check your video there? I think you are frozen. If you can just check that, maybe you can go off and then rejoin again. All right, Mr. Yako Human, may you please then start with your presentation. Thank you very much.
Thank you, Chair. Just give me a moment. Chair, I trust this is visible to everyone. I cannot necessarily see anyone from this end, so please feel free to interject. Chair, the Industrial Gas User Association, of course, is consisting of large industrial gas users, and its main mandate is around the issues surrounding price regulation. The second mandate that IGWASA focuses on is around gas energy security, and as you know, it's a very topical issue at the moment. And then, of course, the third mandate is around policy, gas policy at a national level. These organizations are largely dependent on gas supply, and they have been so for probably the last 20 years or so. Chair, what we would like to cover today is mainly just very briefly some background and opening remarks around what we're looking at and what is being considered by NERSA and Sasol and IGWASA at the moment. We will then move into a very brief legal assessment and similarly a very brief economic assessment. This process, of course, has been duly supported by our team that consists of Norton Rose Fulbright, RBB Economics, and advocates Wim Drengove and Jean Meyring, which is appearing on our behalf today. Madam Chair, what NERSA is essentially considering here today is the assumption of powers to change its own decisions. And in doing so, it appears that NERSA is at pains to really find a pathway and looking at various interpretations of the Gas Act to allow this. But NERSA, the pathway that we see in the documentation in terms of the discussion documents and Sasol's application is, in our view, completely flawed. As a competent regulator, NERSA must be aware of these sort of legal and economic pitfalls and, of course, the risks associated with these potential decisions. And I think what we would like to highlight today is just some of these legal and economic pitfalls and the risks that may be associated with such a decision in granting Sasol its application. What we would like to do is just make these broad, overarching statements. And what we see, Madam Chair, is that in reality, NERSA is not allowing Sasol to recover cost. Rather, it is simply allowing Sasol additional revenue. This is so certainly because if you really look at Sasol's statements around its financial performance on its gas business or its gas divisions, the cost simply did not increase. Sasol uses the word or the language, they suffered in terms of the cost of acquisition, they continue to suffer, but we don't see it in the financial results. And the financial results are publicly available, and if one goes and analyzes these results, one will realize that Sasol actually, their cost position improved year on year, despite Sasol charging constant pricing from FY22 to 23. That's the first statement, Madam Chair. The second statement is that what NERSA is accepting, or even what Sasol is presenting as cost, is actually completely flawed. IGWASA has consistently argued that this notion of cost of acquisition is not Sasol's true cost. And in essence, it is a theoretical internal transfer price. NERSA is also ignoring the potential for cost decreases. In other words, what we fixated on at the moment, and it comes through all the documentation, is this theoretical cost of acquisition. But in reality, it is tied to the first statement, is that Sasol's overall cost in their gas business decreased year on year, despite Sasol charging flat pricing. So NERSA needs to look at the total cost of Sasol's business, and not only this theoretical cost of acquisition that is currently being reflected on in the discussions, the hearing today, and the documentation we've seen. So very importantly, this again puts NERSA at odds with the duties that the constitutional imposed on NERSA to use Sasol's cost, its true cost, as a cost basis. Madam Chair, Sasol's, to demonstrate this, there are various examples around this. The cost of acquisition is linked to oil prices. It is not linked to Sasol's true cost. In reality, Sasol's cost for production, for example, if you just take the production cost element for gas, decreased year on year by 7%. So the cost of acquisition is as far removed from Sasol's cost base as it is in any type of oil index. Dr. Masangane, in response to Sasol, actually said earlier that what Sasol is asking for is that they can recover the costs that are directly applicable to them using, and I'm emphasizing this point, using the international benchmarks that are used in our pricing between our suppliers and ourselves. Now, this is not aligned with the Constitutional Court judgment of 2019, and certainly if we talk about cost of acquisition, it is evident and clear, even from Sasol's perspective and the documentation that we see, that this is not linked to the true cost nor the total cost of Sasol. The third statement is that NERSA is allowing for a change in an approved methodology, potentially, in our view, in an unlawful manner. This is so, as we all know, and NERSA has stated this repeatedly, that NERSA is functus officio. Madam Chair, you mentioned earlier today that NERSA actually did not reach a decision in 2023 in terms of a new price level, etc. A formal decision, that is. And we are not sure why Sasol did not proceed to increase prices at that particular point within the allowed maximum pricing. The only remedy in our view for Sasol, of course, is to apply to the High Court for a review of NERSA's 2021 maximum price decision. The outcome of all of this, in our view, is that it is a complete perverse and irrational outcome that we will see. This, we believe, is so since NERSA will, number one, unlawfully change an approved maximum gas price methodology. This clearly will result in a benefit to Sasol, a 1.16 billion rand benefit, according to our calculations, approximately, for costs that simply do not exist. These cost increases are not real, and it is not being reported on in Sasol's financial reports. NERSA approves, in fact, NERSA would be approving a 27% retrospective increase in the price of gas with no underlying cost basis that we see by Sasol. And this is so because the cost of acquisition, the core focus of all these documents and the discussion today, is theoretical in nature. This, of course, 1.16 billion being recovered from the manufacturing sector, which is already under duress, will no doubt have adverse economic implications. We hope that through these presentations and feedback and our submissions today, that NERSA will come out with a rational position on this. But the matter is serious, Madam Chair, and we will have no choice but to take this matter under the review should this decision be granted to Sasol. Madam Chair, I would like to move on to the legal assessment and ask our colleague, Advocate Jean Meyring, to take us through key points around the legal assessment. Thank you, Jean. Over to you.
Thank you, Mr. Human. Thank you, Yaku. Might I just, by way of the proverbial housekeeping, Madam Chair, indicate to you that shortly before the commencement of this hearing, my instructing attorneys, Norton Rose Fulbright of South Africa, submitted our written submissions. Those are, of course, over and above the slides that we will be using on the screen. We naturally commend those submissions to you. I will, in my address to you, Madam Chair, alight upon the most salient points, both as a matter of law and as a matter of fact, against the background of what has traversed, especially between the panel and Dr. Masangane and Mr. Menkes. I will also alight upon crucial aspects of the factual chronology, which, of course, Mr. Human, in his introductory observations, has already done to some degree. So, Madam Chair, we refer you to that response document. You will know that we asked for an extension and were granted an extension to submit those by today, which IGUA SA has done. And we invite you naturally, in the scope of the time we have available here, we can't take you through every point in the submission, but that's the reason it has been put on paper and provided to you. So we ask that you study the submission, the written submission, very in detail. I will simply be giving you a bird's eye view of the most important points. So against that background, I will first make, and Mr. Himan, I will direct you when to move, but it's fine, you can move on. This is more helpful than the previous slide. It contains more information. So I will start by making our main central take-home points that we invite the panel to, beyond anything else and beyond any of the complexity that might arise in the discussion, the most salient take-home point with respect. Then, Madam Chair, I will alight, as I indicated, upon just a number of, I won't take you through the entire chronology, it's to some degree a common cause. I will take you simply to a few of the most salient points in the chronology that has led up to today and make observations in respect of them. And then, Madam Chair, I will come to what is really the heart of my contribution today, and that is the legal assessment, as is called on the slide. And in the written submission, Madam Chair, it comes at page 19, when you have an opportunity in due course to look at that submission, and it comes under the heading, Sasol's clawback application is flawed. Sasol's clawback application is flawed. So, Madam Chair, panel, the central take-home observations that IGWASA SA invites the panel to reckon with are the following. Firstly, Madam Chair, the only power that NERSA has over piped gas prices is to approve maximum prices, under Section 21(1)(p) of the Gas Act. Once NERSA had taken the 2021 maximum gas price decision to approve maximum piped gas prices for the years FY14 to FY23, NERSA, as far as that power was concerned, was functus officio. As NERSA has itself said, the only remedy that Sasol now has concerning those prices is to approach the High Court, as Mr. Himan already said, for a review of the 2021 maximum gas price decision, an outcome that Sasol has opposed and continues to oppose in the review application that IGWASA SA brought in December 2021 and which was heard well nigh a year ago in the High Court in Pretoria. Now, before I move on to the alighting upon some of the crucial facts, might I just at the end of this is effectively executive summary of our submissions make the following observations. Interestingly, when Mr. Mankies was quite appropriately asked by the chair, but what is, and the chair with respect was entirely accurately and appropriately concerned with the power that NERSA has, and the chair asked Mr. Mankies, but what is the power, what is the legal basis for NERSA to grant a clawback application of this kind? I noted very carefully, as I noted everything Mr. Mankies and his colleagues said. The answer came back, oh, it's Regulation 4.4. Reasonably incurred costs, we know the language. And then Mr. Mankies took the chair to the objects of the Gas Act. And then he went to the appropriate mechanism in the tariff guidelines. But nowhere, Madam Chair, did you hear Mr. Meintjes tell you to section 21(1)(p), because, with respect, section 21(1)(p) is an insurmountable difficulty to this clawback application. And importantly, in the entirely germane, allied situation of the amendment application that was submitted in March last year and was adjudicated, and the reasons for that came out on the 26th of October last year, in that document, and I say germane or allied because it was just this clawback application in a different guise. It was just a different means by which Sasol Gas was seeking to remedy this situation that it had allowed itself to get into. And quite appropriately and with respect, on sound legal footing, NERSA, at that juncture, in response to that application, in its reasons of 26 October 2023, NERSA said, we cannot go down this road. And there were various reasons stated. The central two were, we are functus officio. And then perhaps the second most important one was, we don't in any case have the power to approve gas prices retrospectively. Both of those sound legal propositions, Madam Chair, hold true as much as they did then in October 2023. They hold true now in response to the clawback application. And with respect, Madam Chair, NERSA's response has to be exactly what it was in October 2023. It needs to be Sasol Gas, whatever guidance we might have given in the 26 October 2023 reasons. Of course, NERSA is not a legal advisor. Sasol Gas has very well-paid lawyers advising it. It chose to follow the course of essentially repackaging its amendment application, and it's back before you seeking essentially the same. And the appropriate response, Madam Chair, at this juncture is exactly the same. We are functus officio. We cannot amend prices retrospectively. Your recourse has to be, and this is the slight tweak, has to be to go to the High Court for a review. Madam Chair, I now turn then to make a few comments about the chronology, and they really center crucially upon what happened in respect of the 273, that the adjustment mechanism in 2D2 of the 2020 methodology with respect spat out for the year FY23. Now, a number of salient points, and in the submissions made by Sasol Gas, there was an eliding of the language. There was a rendering vague of the language as to what exactly was produced by the 2021 maximum gas price decision, applying the methodology of the previous year, the international benchmarking methodology. What that process produced, and in line with 21(1)(p), it was the only thing that NERSA with respect could lawfully produce, and that was a maximum gas price. In FY22, it was some 68 Rand. Under the adjustment mechanism in FY23, it was 273 Rand. NERSA, in its submissions, seems to deal with those prices as if they were actual prices that NERSA had directed it to charge. They are, of course, if one understands the legal and regulatory framework properly, nothing of the sort. They were maximum prices over which Sasol could not go. However, as a matter of law, while the 2021 maximum gas price decision stands, as it does today, unassailed under eau de Kral, it was at all times in FY23, or in respect, yes, in the FY23 here, entirely open to Sasol to charge anything up to 273, Madam Chair. So when Sasol Gas, through Mr. Mankey, speaks to you about mechanisms, recognized mechanisms, or a recognized mechanism, Mr. Mankey said, this clawback mechanism. And what were his words? Where there are unforeseen changes that take place. So even on Sasol Gas's own version, this application doesn't get out of the starting blocks because there were no unforeseen circumstances. There was nothing preventing Sasol Gas for charging, yes, below 273, because it was the maximum of 273 that caused concern. There was nothing that prevented Sasol Gas for charging an appropriate price below 273, somewhere between, because clearly its version is that 68 was too low. And of course, you've heard from Mr. Himan that that's not, as a matter of fact, true. And Mr. Lee will explain to us in more detail why that's the case. But just accepting Sasol's version for the moment, for the sake of argument, it was at all times open to Sasol to charge anything between the 68, which it says was too low, and the 273, which at all times during FY23 was the legally approved maximum price by NERSA. So there was much talk with respect about what exactly transpired. And in our submissions, we look at what Sasol Gas says in paragraph 2 and its sub-paragraphs of the clawback application when it describes the engagements between NERSA and Sasol Gas. And it's not quite clear, is it a directive? Was it an agreement? It would seem, in light of what was being said on the part of NERSA in this meeting this morning, that it wasn't a directive. Of course, it couldn't have been a lawful directive because it's clearly outside of Sasol's powers to have done so. So that, as far as the facts then go, might I then, and Mr. Himan, I now get to the slide that we have on the screen, and might I then, against that background, Madam Chair, make the following legal submissions. Firstly, I repeat the submission that NERSA's only power is to approve maximum prices. It can't give directives as to actual prices under 21(1)(p), and of course with that has to be read 4.3 and 4.4 of the pipe gas regulations. So NERSA does not have the power to permit Sasol to claw back acquisition or trading costs, namely to charge customers in one period for costs that it had failed to recover in an earlier period. When it took the 2021 maximum gas price decision, it exercised its powers, as I said before, to set the maximum prices for the entire period from FY14 to FY23. It is accordingly functus officio. Indeed, Sasol has taken this view, as I've said before. And of course, there's also the point that it cannot take a retrospective decision. And again, Sasol has taken that position. And then, over and above the fact that Sasol does not have the power to grant the clawback application, the very basis, as we see on the slide, of the clawback application is irrational. We say this, Madam Chair, for the following reasons. And these are my closing observations, but I'll take you through them in a little bit more detail. The maximum gas price in FY23 was determined in accordance with the 2021 maximum gas price decision, namely on the basis of international benchmarks. And we by now know what was produced under that decision for FY23 was 273 per gigajoule. Under NERSA's rationality test in the 2021 maximum gas price methodology, the lower bound of the maximum gas price in FY23 would have been equal to Sasol's acquisition cost. However, being as high as it was, the maximum gas price of 273 was in no way affected by Sasol's acquisition cost. It therefore follows that if Sasol had experienced an increase in its acquisition costs in 23, in the order of magnitude claimed in the clawback application, such an increase would not have placed upward pressure on the maximum gas price in that year. The only reason that Sasol did not increase its prices in FY23 in line with its changes in acquisition cost was this alleged agreement or agreement with or directive from NERSA. Then Sasol says that it will add the surcharge to the monthly statements sent to its customers. And you didn't, in questioning Mr. Mankies with respect, get a clear sense of how that would work. And we say there are two options, and that you see at F1 and 2 on the screen. It seems that Sasol proposes to charge the surcharge to its customers during the clawback period on sales made to them during that period. That would be irrational and incompetent. So, since Sasol would then levy the surcharge to customers and on sales during the clawback period for the additional costs it incurred in supplying gas to other customers on other sales in FY23. The other option or possibility is that Sasol plans to invoice its FY23 customers again for the sales made to them in FY23. But clearly, NERSA may not authorize Sasol to charge an additional price today or in the future on sales made to customers in FY23, for which they've already paid Sasol. For all these reasons, we say a decision to grant the clawback as far as both the acquisition and the trading cost go would be unlawful. That decision would be plainly reviewable under PAJA as well as the principle of legality. Might I, just before I close, address one point? Those are our fundamental submissions. We say with respect, Chair, you don't need to go beyond those fundamental principles because NERSA does not have the power. But then might I just refer the Chair to submissions that IGWASA delivered to you in September 2023, and we will, to the extent necessary and for the convenience, I will arrange that my instructing attorney submit this to you. But we say, and there's no basis upon which the submissions we've made about power do not hold, but we do in those submissions, and we'll draw your attention to those. We say that even if for some reason the trading cost formula does apply, we say it doesn't, because you can't get beyond what the legislature provided in 21(1)(p. Then we say it's in any case irrational to apply the trading cost formula to acquisition cost. So for all those reasons, with deep respect, we caution the regulator that approving this application would be as legally unsound as your having approved the amendment application a year ago. It would be reviewable under PAJA. It would be unlawful. My time, Madam Chair, then hand over to Mr. Lee.
Thank you very much. I would also just request you to just note the time that you've started and the fact that we granted 30 minutes so that if you request additional time we also just consider that, so that
Madam Chair, might I at this juncture indicate to you that since, in fairness, I didn't quite keep track, but Sasol was allowed a significantly longer period, and we've got to deal with the complexity of what they've put up for the assistance of the regulator. Might I ask that we be given an appropriate time that Mr. Lee, who won't be very long, just reach the conclusion of his submissions, Madam Chair, with respect for the assistance of the regulator?
There's no problem with that. All that I indicated in terms of the rules that I've stated. If you
I'm indebted to you, Madam Chair. We're indebted to you.
30 minutes, if then, because the Sasol saved 4 minutes, I've looked at it carefully. So if you then need more time, we can consider that and grant it. And also keep in mind that during the questioning, we add more time, not on the 30 minutes, but extra time. So if that can be considered. And Mr. Lee, you may go ahead, please.
Thank you very much, Madam Chair. I really don't want to take too much of your time. I just want to raise 2 very brief economic points.
Raise all the points that you would like to raise. We will allow you to do so, so that we do not prevent you from making the economic arguments and present economic evidence if you need to do so. Thank you.
Thank you, Chair. They were in any case going to be brief, so but I'm indebted to you. Chair, the first point that I want to cover is a conceptual issue around the recovery of acquisition costs generally, and this also underscores the submission that Mr. Human made in his opening remarks. Now, Chair, what we know is that Sasol Gas's acquisition cost is not determined by the actual costs that are incurred to extract the gas molecule in Mozambique. Instead, what we know is that it is based on benchmarks, and those benchmarks can move independently of those actual extraction or production costs. And those benchmarks, as we know now, are also based on indices that I'm instructed that the South African courts have dismissed as being a basis for pricing in South Africa. And what this means, Madam Chair, is that the amount that Sasol Gas pays to acquire the gas molecule from the upstream entity in Mozambique can increase without a corresponding increase in the costs of the upstream entity. And in this case, profits are then simply shifted from Sasol Gas to the upstream entity, in which, of course, Sasol has a majority interest. So in turn, if Sasol Gas is then permitted to recover the increase in acquisition cost by raising prices to its own customers, then this would lead to a double counting of profits for Sasol's gas business, and of course, direct harm to purchasers of piped gas. And Madam Chair, this is illustrated in Iguasa's written submission by way of a set of worked examples. This, we submit, Chair, is irregular and would not be fair or equitable. It also suggests, Madam Chair, that NERSA should seek to understand the actual economic costs associated with both the production and the selling of piped gas in going about its regulatory activities. I also note, Chair, that this is not a new point. Rather, it's the same point that Iguasa has raised in previous interactions with the regulator, including in relation to the impact of the acquisition component in the current maximum price methodology. Madam Chair, the second point that I want to highlight relates to the question of whether the relevant costs did indeed increase between FY22 and FY23. And this again underscores one of Mr. Human's opening remarks. Now, we understand from Sasol's submissions that the acquisition cost increased between FY22 and FY23. But this then raises the question of the other operating costs of Sasol's gas business. Did they increase? Did they stay the same? Or did they decrease? And to investigate this question, we've considered the gas business results contained in Sasol Limited's Analyst Handbook for the financial year ended 30 June 2023. And what do those results show? Well, they show that Sasol's gas business did indeed experience an increase in cost of sales between FY22 and FY23, which might be interpreted as having been influenced by a change in the acquisition cost. However, Those results also indicate that when considering all operating costs, including cost of sales, the costs of Sasol's gas business, in fact, declined between FY22 and FY23. And what this serves to highlight, Chair, is that although the gas business might have experienced an increase in acquisition costs in FY23, it was evidently able to achieve material cost savings that more than offset any increase in acquisition cost at the EBITDA level. In other words, Chair, by entertaining Sasol Gas's clawback application on ostensible increases in acquisition costs only, not all relevant costs are on the table. Yet, I'm instructed that NERSA is required to consider all relevant costs, not only acquisition costs. Indeed, if the clawback application were to be approved only on the basis of an ostensible increase in acquisition cost, the available information indicates that Sasol's gas business would be awarded a significant monetary windfall in circumstances where its profits at an EBITDA level in reality increased in FY23. And based on the data that's available to us, we estimate that this windfall would be in excess of R1 billion, which will then have to be absorbed or recovered by an already struggling manufacturing sector in South Africa. This, Madam Chair, would self-evidently be an irregular outcome. And at the very least, we submit that it warrants further investigation and consideration by the regulator, given its access to Sasol's information. Jaco, if I could ask you to move on to the next slide. And Madam Chair, this table, which also appears in IGWAS's written submission and is more fully explained there, summarizes these findings. It shows that the EBITDA position of the gas business improved in FY23 relative to FY22. It also shows that if the clawback were to be granted, that EBITDA position would improve even further. Madam Chair, this is inconsistent with the idea that Sasol would be left out of pocket if the clawback were not to be approved. This, we repeat, Madam Chair, would be highly irregular and would also not be fair or equitable. Thank you, Chair. I'm going to leave those points there. I thank you very much for your time.
Thank you very much, Mr. Lee. Mr. Human.
Thank you, Madam Chair, once again for the opportunity. We are in your hands.
All right, thank you very much. Members, may you please engage with the presentation from IGWASA by asking questions of clarity so that we can understand exactly what they are saying and also the evidence to the extent that they've made certain arguments. May you please, by show of hands, members, indicate whether you do have questions to ask. Mr. Kumete, please, you can go ahead.
Thank you, Chairperson. I've just got two questions for Advocate Mering. Just questions of clarity that I'd like to pose so he can assist us when we make a decision. The first one is in his representation or interpretation of law. I kind of got a sense that says, and maybe that's what I'm just trying to get an understanding of. Does a clawback application amount to NERSA revisiting its decision, or is it about making a new decision? It's just for me because I'm struggling with this. That says, yes, there may have been a decision, but maybe in the methodology, if the methodology allows for a clawback, so when a clawback is applied for, would that amount to a NERSA being funcus officio? So that is the first question. It's just a clarity, Mr. Mering. I think then, linked to that, I guess my second question is, a clawback has generally been an accepted principle in NERSA's methodologies. Are you therefore perhaps suggesting that this is incorrect in the sense that the clawback may in fact amount to future customers being charged for costs that were incurred by other customers. They may well be the same customers, or may not be the same customers, or the clawback may amount to the revisitation of the charges that may have already been made on the past sales. If I can just get that clarity, I'm hoping my question is clear. Thanks.
Thank you, Mr. Gumede. Mr. Mkhize.
Thanks, Chairperson. From my side, just one issue on the economic analysis part of it, or the financial analysis part, where it's indicated that they did make a profit and therefore did not suffer any loss. I'm not so clear whether that one is coming out exactly. Maybe when you provide the analysis, it will help maybe to make it very clear, because if there is a cost that is incurred, but it is such that the cost of sales are still much lower than the revenue that has been generated, you will still have a positive figure, which then is a question of saying it could have been more positive, if I can use that term, than what it is. Therefore, signifying that there is a loss that you had or forfeited revenue. I just want to be able to get that clarity, and I hope that your analysis will actually go to pinpoint that there was indeed no loss as such, as much or as far as it pertains to the cost that Sasol alleges to have incurred. If you can be able to, in that analysis of yours, be able to unravel or uncover that, so you can talk directly to this matter, because just by a figure being positive or negative does not necessarily of its own say that there were no costs incurred. Just to bear that in mind in your analysis that you provide to the team. Thank you.
Thank you, Mr. Mkhize. I do have some questions as well, if you can kindly take them down as well for clarification. I do want to start on the issue of the acquisition cost, because those are costs that are mentioned in the methodology that NERSA uses to start off with, but also just to get an understanding as to whether IGWASA is in a position to provide the regulator with evidence showing that no increase was experienced by Sasol in terms of the acquisition cost of gas. I think that will be fair, so that when you make certain assertions, such assertions must be substantiated and assist the regulator then in really understanding and considering your assertions carefully. So we would like to get that information from IGWASA if it exists. The second thing that I would like to clarify is whether IGWASA or your economist, RBB in this case, whether they have considered a consolidated or integrated reporting, the annual reporting on the costs, or did they get a detailed cost analysis of the gas business, so that they can accurately identify cost pertaining to the gas business, so that they can point us exactly where they believe that no cost increases encountered by Sasol Gas. I think that is very important, and I think that it is generally accepted, obviously, when economists deal with issues of worrying about price or excessive pricing, that even to look at the consolidated reporting, it might not assist you in terms of coming to the accurate cost of the business, and where you don't even have the management account for that specific business. So that is generally something that it becomes very difficult, a challenge for economists, unless that cost is one that is made available by the entity concerned. So from my side, from an economic point of view, I do want to get a sense as to where RBB got that information. So if that can be made available. The third thing that I would like to understand here, there are also commercial considerations and cost pertaining to commercial operations. Does RBB, or as well under IGWASA, obviously, does it suggest that we must only consider economic costs and not take into account the commercial justification and rationale, to the extent that those are costs that will enable the business to continue and be on a sustainable basis? If that can be clarified, please, so that we get a better sense here between economic costs as well as the cost of ensuring that the business can be run sustainably. If that can be clarified, so that those are the things when we deliberate, we need to take into consideration. And then there are issues as well. Or let me get to the issue of the trading cost. I think Mr. Mayer made mention of Section 21(1)(p). Mr. Mayer, when he did so, he does not explain to us in the way that we need to operationalize Section 21(1)(p), to the extent that we talk about applying it in a prescribed manner, meaning that there are regulations, starting from Regulation 3.3, for instance, where it says that for Section 21(1)(p), NERSA must have a systematic sort of methodology that it will use to then come up with prices. So that is Regulation 4.3. Then Regulation 4.4, and I would like to emphasize this because Mr. Mayer left it out and say that we don't have powers to consider a trading margin at all. But it seems to me, and this is the clarification that I require, that even the Constitutional Court in its judgment delivered in July 2019, it provided guidance as to how NERSA has to navigate its regulating task. Those are the exact words that were used in the Constitutional Court judgment. How NERSA is supposed to navigate its regulating task when it applies Regulation 4 sub 4, of which regulation states clearly that when you deal with prices, you must make sure that you allow the licensee to recover prudently as well as efficiently incurred cost. And then it goes further to then say, to say that also that licensee, we must make sure that it makes a profit commensurate with the risk. So all of that is in Regulation 4 sub 4, of which the Constitutional Court tried to guide NERSA as to how it has to navigate its difficult task of regulating. So does it then, is Mr. Mayer then saying that NERSA does not have to consider the trading cost because there will be trading assets? And we are saying that, remember, the trading assets are not necessarily your distribution pipeline only, as well as your transmission pipeline. So there will be those assets, even for independent traders, that they are claiming themselves, not only Sasol, but their trading assets. So those trading assets regulation 4.4 comes in. So I am a bit confused then by the statement that all that we have to consider is just 21.1p, but the regulations of how it's supposed to be operationalized seems to have been ignored in the presentation. I would like clarification if I got this wrong. We can just be clarified.
Thank you.
Sorry, I need to put these questions because they are very important. They were raised, and it shows also that we were listening very carefully to the presentations. And really, we have to take each point, and for that, it also shows that we thoroughly considered the arguments that were made, so that each argument then is properly clarified, and we can see how we apply our mind to each of the points that you prepared for us. So for me, that is important. I do want to ask also whether there's an argument from ICWASA that says NERSA has no power and no powers at all to consider clawback, even if there's under recovery by the licensee. Remember, by the and this is acceptable, it's an acceptable sort of what is it? Risk. When regulators are tasked to determine maximum prices, there's a risk of determining that maximum price very low or determining the maximum price very high. That is acceptable. You'll find it in any paper that you can actually go to. But in any event, there's an economic rationale for it where the market can be competitive. So that is the economic consideration. Now, in this case, to the extent that the maximum price has been that was used has been low, such that the company then under recovered, and that is a risk, as you will appreciate, that regulators are not supposed to allow companies to have a shortfall on revenue. That is not disputed anywhere. Otherwise, then it will push that company out of the market. So I'm asking here, are you saying that the regulator has no powers to consider clawback? And in this case, is it because you are saying that the adjustment factor, remember the decision of NERSA had an adjustment factor. That decision that had an adjustment factor is the one that Sasol says that we did not adjust it sufficiently, and therefore and also at the same time we experienced increasing cost whilst the price was constant. So you have a situation of a constant price, but the cost is increasing. And now they say that adjustment was not sufficient. And we did not use an adjustment that was initially there because it would have resulted in what you call in absurd prices or irrational outcomes. I did not understand the application to mean that NERSA is here to approve cost. I was understanding that the application for the clawback is because the adjustment part of the decision did not enable the licensee to recover its cost. So I just want to check that aspect if we're understanding it the same way. May I stop here from, before that, can I then get this information as to where does ICWASA get the evidence that Sasol's cost have decreased year by 7%, when Sasol actually, as the owner of the information, says that its cost went up? Because we really need to see where does this come from, because we've got this cost information from Sasol, and then there's other information that says actually the cost decreased. If we can get that. Thank you.
Thank you, Madam Chair. We noted in total 9 or 10 questions, and I will come in answering your last question first, and then I will defer to our economic colleague as far as these economic questions are referred to the economic submission or assessment, and then, of course, Advocate John Mayring insofar as these questions relate to the legal assessment. With regards to evidence of Sasol's costs, these are well publicized publicly by Sasol. It's available on their website. If you look at Sasol's entire gas business, and this is where the entire gas business, as Sasol reports on it, actually is net of its shareholding, interest, upstream, downstream, and it reflects on the performance of the overall business, including trading, including cost of acquisition, and other costs. The reason why I refer to other costs is linked to your comment, or my comment rather, around the decrease in production costs. So it is true in Sasol's F20 submissions of 2023 to the United States Security Exchange, Sasol reports on their production costs for gas. But Madam Chair, the point is, and the outcome of that is that the cost actually decreased by 7%. The point of all of this is that there are many cost elements, or the total cost structure of the Sasol gas business is not only limited to gas trading or the cost of acquisition. The cost of acquisition, as we've now determined, is linked to some international index, which of course has been rejected by the South African courts. So these documents, we're happy to provide these documents and take you directly to where we pick up this information. But let me pause there, Madam Chair, and I'll defer to Simon in terms of the economic responses, and then Advocate John Mayring insofar as the legal responses are concerned to the questions of yourself and your NERSA colleagues. Thank you very much.
Thank you, Yaku, and thank you, Madam Chair. Madam Chair, I'm going to start with your question about the source of the information that underpins the table that I presented just a few moments ago. You asked whether or not that pertains to a consolidated Sasol or whether it is specific to the gas business. I can confirm that it is specific to the gas business. The results of the gas business are reported in Sasol Limited's Analyst Handbook. We explain that in the source of the table, both in our presentation and in the written submission that has now been provided to NERSA. So that is specifically for the gas business. I think what we'd be happy to do, although the document is publicly available, we can certainly share it with you and your team after this. But just to clarify, we haven't looked at Sasol on a consolidated basis. We have looked at the results that are specifically highlighted as being for the gas business. Maybe then I can move on to one of Mr. Nkize's questions. He asked if we can provide evidence on a decrease in acquisition costs. I believe that was the question. Maybe I just need to clarify here. Our submission is not that Sasol Gas's acquisition cost decreased between FY22 and FY23. We obviously don't have a lot of insights into those movements. A lot of that is confidential, as in Sasol's application and in the discussion document. So we take it at face value that Sasol's acquisition cost increased between FY22 and FY23. Our submission is rather that when you look at operating costs, more generally including costs of sales, which we understand would reflect the acquisition cost, those operating costs actually declined between FY22 and FY23 based on the information that I've just spoken about as reported in Sasol Limited's Analyst Handbook. I believe there was another question about what costs should we care about? Should we be caring about acquisition costs, economic costs, or do we worry about what is going to make the Sasol gas business run on a sustainable basis? I think our submission I think covers all of that, in the sense that when you look at the results of the Sasol gas, or of Sasol's gas business in FY23, we see that its EBITDA profits actually improved relative to FY22. So our submission is simply this notion that Sasol Gas suffered some harm on a net basis in FY23 relative to 22 is a little bit misguided. Its profits at an EBITDA level actually increased. And if the clawback were to then be granted, it means that that EBITDA profit would then improve even further in FY23. And that clawback would then have to be recovered or absorbed by an already struggling manufacturing sector in South Africa. And we submit that that is not an equitable or fair outcome. In other words, Sasol's already improved EBITDA position in FY23 would be further improved to the detriment of purchases of pipe gas in South Africa. Now, I also take Mr. Mkhize's point that, okay, well, yes, maybe other costs declined and that offset an increase in the acquisition cost. But that still means that in a relevant counterfactual, where that increase in cost was allowed to be recovered, that Sasol's gas business would have been in an even better revenue or profit position. And I take that point, but again, my submission here is, would that be equitable and fair? If we already have Sasol's gas business having an improved EBITDA position in FY23, would it be equitable and fair to further improve that EBITDA position to the significant detriment of purchases of pipe gas, especially considering when, as I understand it, NERSA's mandate is to consider what a competitive price would be. And our submission is that if, on a net basis, Sasol Gas's cost decreased, then a competitive price would not increase. Chair, the other point that I wanted to address very quickly was your question around, does Sasol have no power to grant a clawback? And of course, this is squarely a legal question, so I'm going to defer to my Advocate Mayering here. But I just want to speak to this at least from the perspective of economic logic. I think what we would say is, yes, NERSA must be careful of setting a maximum price that is too low, because what that might result in is Sasol Gas being forced to charge a price that forces it to under-recover on its costs. But our submission here, Chair, is that in FY2023, the maximum price was not low. It was very high. It was 273 Rand per gigajoule. And that, I understand, Chair, means that Sasol could have increased its prices in FY23 to account for these additional acquisition costs that it is now claiming. And that the only reason that it didn't was that there was some agreement between Sasol and NERSA for Sasol not to go ahead with that increase. I'll, of course, defer to Advocate Mayering here on the legal points, but that is at least my understanding of the situation. Chair, I hope that covers everything.
Just before that, I'm not sure about the agreement that you are talking about, and this must be corrected, and I've tried to correct it. What we are saying is that we resisted, as the regulator, any increase that will be like more than, that is 200% from what we have said, the decision of 2021. Because we also stated that it will be economically irrational, because we don't believe that even the cost increase of Sasol would amount even to 50%, such that it will be justified to even adjust its prices. Yes, we know that the decision says you must adjust, which is probably because it was a multi-year price increase. But we then said the extent of adjustment, if you want to adjust it by 50% or 100% or 200%, that cannot be allowed. I think that's the essence of what the regulator said to Sasol. We never said don't do it, but we said we do note that you seem to want to adjust with a percentage that will allow you to enjoy a windfall. That's what we said. And we said, for that reason, we will not allow you to adjust. So that must be made very clearly. And then if I move away from that, you made a point that the courts rejected the benchmark. I don't know where in the judgment of 2019, even the judges themselves, who are not economists, the judges themselves, they made it clear that a competitive benchmark is an acceptable, internationally acceptable way of pricing. And then it said, however, when you do so in a market where you are facing a monopolist, you do need to take into account its marginal cost. That is what is in the judgment. They never said competitive benchmarking is not allowed. I would not see it anywhere. I've never seen any empirical evidence or anything that says competitive benchmark is actually not allowed, even from a competition point of view, by the competition economist, when they look into the dominance as well as the excessive pricing. Competitive benchmark, they use it, and I just want to understand, where does it come from that benchmarking was rejected? Because the Constitutional Court said you can't just use or rely 100% on competitive benchmark, even if it's an acceptable approach, without considering the marginal cost of a monopolist. That's what is in the judgment. I just want to get your comment on that so that you can then refer us, because we do have the copy of the judgment. If that judgment now says never use this, I did not get it. Thank you.
Thank you, Chair. I'm going to defer to Advocate Meyering on these 2 points, as I think that they're legal in nature. But maybe just to clarify my understanding on the first point, I understand that there was a directive from NERSA that Sasol should not increase its price in FY23, but my understanding is that the maximum price as determined by the international benchmarking methodology in that financial year remained at 273 Rand per gigajoule. But like I said, let me please defer to Advocate Meyering here.
Please, Mr. Meyering, may you please go ahead?
Madam Chair, I'm going to deal with the question sequentially. I will, when we get to this last point about benchmarking, I will, in due course, just seek some clarification, because it seemed as if you were saying that Mr. Lee had said something about benchmarking. But might I just deal with the first questions first, and then when we get to that, I will ask the necessary clarification. Madam Chair, might I then deal with the 2 questions directed by Mr. Gumede, and then I will turn to the 2 initial questions first that you, Madam Chair, directed. Now, Mr. Gumede first asked whether the clawback was revisiting a decision of NERSA, whether it was a new decision. Now, it is a taxing, sort of almost existential question whenever there are sequences of administrative decisions. To what extent is it revisiting an earlier decision? To what extent is it a new decision? Of course, it's a bit like 6 of the one and half a dozen of the other. But the important point with respect, and having considered carefully Mr. Gumede's concern, the important point with respect is that there is an existing 2021 maximum gas price decision. It is valid. It stands under the principle of eau de Kral. The only way of assailing that decision is by going to the High Court to have it set aside. So that, with respect, is the important starting point. And so whether one seeks to revisit that decision, or whether one seeks to take a new decision in respect of the same subject matter, it matters not, because eau de Kral prevents both of those. Eau de Kral prevents both of those. And in fact, it's clear that the understanding of both NERSA and Sasol is that that decision stands. The amendment application which Sasol brought, which in fact had been at the suggestion of NERSA as a matter of fact, was an attempt to get around eau de Kral. In due course, obviously properly advised, because the reasons of 26 October have a lot of law in them, NERSA realized, but it can't do it that way. We say it also can't do it in this way, because whether it's new or whether it's revisiting, eau de Kral prevents it. Secondly, Mr. Gumede asked, but how does one now see this clawback? Is it charging new customers in respect of the past period, or is it charging past customers in respect of that period? Now, on our slide, and Mr. Gumede, at paragraphs 59.1 and 59.2 on page 22 of our written submissions, we address that point. And I did substantially read those two paragraphs in when I made my submissions, and it says we essentially say we don't know. The clawback application doesn't tell us which of those two alternatives will be implemented, but we say in 59.1 and 59.2 that both of them would be unlawful. Both of them, both of those modes of structuring the clawback would be unlawful and reviewable. So those are Mr. Gumede's questions. I turn then to the questions directed by the chair. The first one was the suggestion, the two verbs are navigate and operationalize, and Madam Chair referred to the Concord judgment and suggested that I had elided the regulations. Not at all, Madam Chair. I simply didn't refer to them in detail because of time constraints. They are dealt with in our written submissions. And the point that I made was that you cannot, when you deal with questions of power, and that clearly is a central concern, as it has to be for the regulator, you cannot start with the regulations. You have to start with the statutory provision, and in this case, it's 21(1)(p). So my point was really that is the starting point of any inquiry. And of course, Regulation 4.3 and Regulation 4.4 are important. So I didn't say that the trading, well, that's the next question. I totally take account of the fact that a methodology is the way, by publishing a methodology, as NERSA has done repeatedly, the 2013, 2020, and now the 2023 methodologies. Those are exactly the ways in which NERSA does try and put in place a systematic way of allowing a licensee to get the layer of fat, if I may be allowed that metaphor, that is envisaged by Regulation 4.4. But the time at which this regulator has to apply that criterion that the Constitutional Court emphasized. In other words, the juncture at which the regulator is to determine that to ensure that the licensee gets that additional band commensurate with risk, profit commensurate with risk, is the time when the regulator takes the applicable maximum price decision. And that's exactly what NERSA did when it took the 2021 maximum gas price decision. And what's important, and this echoes Mr. Lee's observations at the end of his answers, is that's exactly what NERSA achieved. Because through the adjustment mechanism in 2D 1 and 2 of the 2020 methodology, it allowed a figure to be produced by the methodology for FY22 and for FY23. And for FY22, it was 68 Rand. For FY23, that maximum price was 273. And that maximum price that NERSA approved did allow in applying that methodology, it did allow the licensee to get enough of its profit commensurate with risk. So NERSA did exactly the right thing at the time. And the fact that Sasol chose not to add on to its price profit commensurate with risk, that with respect is a decision that Sasol has to live with. Milady then, Madam Chair, the question then lastly, in terms of the questions specifically directed, were does NERSA have no power to allow a clawback? I'm just reading the question, Madam Chair. No powers at all to consider clawback for recovery. Now, in this case, to the extent that, yes, we say, Madam Chair, that the regulator, what the regulator did in the methodology of 2020 was exactly to allow for an adjustment in respect of FY22 and FY23. The adjustment factor did in fact, and you suggested that NERSA's position is that the adjustment factor didn't allow it a sufficient margin, but in fact the adjustment factor did. It simply didn't implement that. It didn't use the full scope of the maximum price, or what the maximum price allowed it. So we say that a methodology can certainly provide for an adjustment factor, but a clawback application like the present one, and with respect, Madam Chair, it's a complicated legal question asking in the round, as a general proposition.
Sorry, Mr. Meyering, I actually lost you for like 2 minutes or so. I think perhaps the problem was from my side, the internet from my side.
Yes, Madam Chair, I'll just summarize. I'm getting feedback and hearing. Yeah, I'll just summarize. As far as your first question goes, we say that the regulations are, of course, important. I didn't suggest otherwise. I simply said the starting point has to be 21.1p. 4.3 and 4.4 are crucially important, and they were taken account of when the regulator devised and published the 2020 maximum gas price methodology, and its complicated structure 2D 1 and 2, which allowed then forward looking for FY22 and 23, did exactly that. And in fact, if it were implemented in its terms, it would have been entirely compliant with the methodology that is, as it were, envisaged by the ConCourt in its appraisal of regulations 4.3 and especially 4.4. So what the regulator did up until the decision that Sasol took to limit itself to 68 in FY23, the regulator acted appropriately. It acted as far as this point is concerned. It did act systematically, and it did allow Sasol Gas to obtain not only the costs that it had incurred, but also a margin of profit commensurate with its risk. I think there was an error in translation, perhaps, as far as trading costs go. I didn't say that there wasn't a power in the regulator to also take account of that when it devises a methodology and publishes a maximum price decision. I, at the very end of my submission, simply said that even in a world where clawback were permissible, and that's not our contention, we say it isn't permissible, but even if it were permissible, it could never be permissible to use the tariffs, the trading cost formula, to which on some reading might, we say, unlawfully permit a clawback. It can never be rational to then apply that to the GE price. So we didn't say, I think there was possibly an error in translation there. But then, Chair, going to the last question, you asked whether the regulator does not have a power to recover a clawback. We say that the methodology of 2020, cleverly devised, it provides an adjustment mechanism forward-looking for at that point for FY22 and FY23. That adjustment factor, it can't be for Sasol to say it didn't provide a sufficient margin. It did. It produced a price of 273. So I was at the point when you rejoined, Madam Chair, I was saying it is a difficult, broad question that I would have to do research on to answer. Well, does NERSA not have the power at all to recover a clawback? What we say is, on these facts, at this point, on these facts, this clawback application is unlawful. Why? Because it breaches inter alia the principles of functus officio and of retrospectivity, and it does something different than 221(1)P allows, which is forward-looking to approve maximum prices. And so to the extent that a clawback application breaches even only one of those foundational principles of our administrative law, then yes, a clawback would be unlawful, and the regulator wouldn't have the power to approve a clawback. So the crucial point, Madam Chair, the crucial points is in the regulatory role of NERSA is initially when, in compliance with the Constitutional Court judgment and Regulation 4.4, it devises that systematic methodology, the methodology in this case of 2020. And the next crucial point is when it applies that methodology in deciding a maximum price decision. And those were the points at which NERSA quite properly took account of all these various factors it had to and made a maximum price decision. Sasol Gas chose not to implement that maximum price, or it chose not to go up beyond 68. That was a decision of its own. And with respect, if the regulator instructed Sasol to do that, then that instruction with respect was an unlawful one, because the regulator does not have the power to direct to a licensee the price that it is to charge. 211P foundational, the power that NERSA has in respect of prices gives NERSA only the power to approve a maximum price, which is what NERSA did when it handed down the 2021 maximum gas price decision. NERSA, with respect, had no powers at any time subsequent to that or at any time to instruct a licensee what to do. But that's a separate debate. What is clear is that Sasol acted in a certain way, and it has to, with respect, live with the consequences of that, or go to the High Court to have assailed whatever it chooses to assail. Madam Chair, then just the question that I said I would ask clarity on about the benchmarking. I didn't understand Mr. Lee to say that the Concord decision spoke specifically to benchmarking, but perhaps, Madam Chair, you can just clarify that concern, that question with me.
Mr. Meyering, there is mention that it is not appropriate to consider benchmarking for the South African market.
Yes.
What I am saying is that the Constitutional Court judgment never said that competitive benchmarking, because they know that they will be wrong, and they will not have for matters such as economic regulation and even on competition matters to then say that competitive benchmarking cannot be considered. The Constitutional Court stated, and you can refer to that paragraph, that competitive benchmarking is an internationally acceptable approach. However, where you have this market structure, where you have a monopolist, it says, NERSA, you cannot ignore the marginal cost of that monopolist, because then you are running a risk, and this is my emphasis now, the last part, you are running a risk of then perhaps approving a maximum price that will be excessive. This is my emphasis, the last aspect. So what one deduces from that is that, yes, even in instances where you want to compare, you do the competitive pricing. I mean, there's a mention of competitive pricing. My understanding from an economic point of view, competitive profits, competitive pricing is not something that you're saying you're just looking at the cost and the price. You also look at others in a similar situation and in markets that are competitive. So that's what you will be looking at when you talk about competitive prices, competitive profits. So that competitive benchmarking consideration is an economic reasoning to arrive at a decision. is there's nothing wrong with it, but they say you can't consider that competitive. And then what if then you have allowed a huge layer of fat because you have ignored the cost? That's the simplification of it. So that's what I'm saying the Constitutional Court touched on.
Yes, Madam Chair, I think Mr. Lee will have a sentence or two to add to what I'm just going to deal with the legal point. No, to the extent that the notion of international benchmarking was addressed by the Constitutional Court, it would have been what lawyers call an obiter dictum, something said in passing, because the issue, Madam Chair, was not pleaded out in the High Court SCA or pleaded out in the Constitutional Court or argued. Why? Because it wasn't part of the factual matter that Gug, the predecessor of Iguasa, was then complaining about. So it isn't something that the Constitutional Court pronounced upon. However, Madam Chair, as you are aware, the High Court in Pretoria is currently seized of an application in which Iguasa does make out the case that the international benchmarking applied in the 2020 methodology is in fact unreasonable and irrational. We're awaiting the outcome of that court case, but in that judgment, this question would surface. Mr. Lee.
Thank you, John, and thank you, Madam Chair, again. Madam Chair, I think I'm largely aligned with what you've just said. I certainly would not submit that international competitive benchmarking has no place in regulation or indeed in other types of competition assessments. Our point was merely to point out that in previous litigations, the courts have indicated that you need to be wary of the types of benchmarking that you apply. And as you say, I think in the context of the international benchmarking methodology, for example, it was clear that benchmarking prices against hub prices elsewhere in the world, in the United States and in Europe, produced prices, although they were based on benchmarks, that were not reflective of a competitive outcome in South Africa. And I think you said it very clearly, is that what matters is similarity. In other words, are those benchmarks that you are using as comparators, are they reliable as proxies, and do they account for the realities of the competitive conditions against which you're trying to benchmark? So I think the point there is that international benchmarks we do not submit are never useful. The point rather is that when you use benchmarks, you need to do a layer of analysis to make sure that those benchmarks are appropriate. And I think what we're saying here is that we understand that Sasol Gas's acquisition costs are based on some international benchmarks, including the price of oil, for example, but then that likely means that those acquisition costs are not reflective of the true costs incurred in Mozambique to extract and produce the gas molecule. That is the extent of our submission, Chair.
Okay, thank you very much. I'm clear on the issue of benchmark, and I'm glad that as an economist, you do understand its relevance and what circumstances it may be considered. I do have a question that comes from the audience that we would like to pose. So I will just read it quickly so that you can get an opportunity to respond to it. The question, and it's also a comment, is that the financials being quoted are not Sasol Gas Pty Ltd financials. They are the consolidated financials for gas value chain business, which includes gas infrastructure business, that is pipelines, distribution pipeline, as well as transmission pipeline, the financials that are being used. And as you know, for the transmission and distribution pipelines, those pertain to the tariffs. And then they are saying that they are not necessarily for Sasol Gas when it comes to the charge for the molecule, how much is being made, which is the subject of today's hearing, as we are not looking into the tariffs. I just want to read out. That's what we received. Thank you.
Thanks, Chair. I know there wasn't a question embedded there, but maybe I can respond with a comment myself. I agree. What we have looked at is Sasol Limited's analyst handbook, and we have relied on the results for the gas business. And we've presented the results on that basis. That is why I submit to you, Chair, that in light of these results, we would encourage the regulator to investigate this in a little bit more detail. We, of course, don't have the benefit of having detailed information on these kinds of things. That's why we pointed this out, and we think that that is a sufficient basis for the regulator to then say to itself, okay, maybe this is something that we need to look at a little bit more detail, using the powers that we have to obtain information from Sasol Gas. My second comment on that, Chair, is that even if it doesn't relate specifically to Sasol Gas, it's still relevant to consider what the financial position of the gas value chain was. In other words, we still see that even if it is a longer value chain that we're considering there, that financial position of the gas business as a whole did improve, and that providing this clawback would further improve the financial position of that gas business to the detriment of purchases of pipe gas. Thank you, Madam Chair.
I think, Madam Chair, if I'm allowed just to add to that, if the notion is that one should look at the molecule cost as the molecule cost, then of course the starting point there is 10 Rand a gigajoule, which is the production cost of the molecule. You're on mute, Madam Chair.
Thank you, Jaco. Is there anything else that you would like to add before we move on to the next presenter?
Other than to thank you again for the opportunity, Madam Chair, and we wish to engage you further if needed. Thank you very much.
Thank you very much. Thank you, Mr. Meirang. And I think you also promised to submit information of that you made in September 2023, I think. You made mention of that. And remember, we also did not get the benefit of looking at your written comments, but we'll take those into consideration. And we appreciate the fact that you have availed yourself today to participate in this hearing so that you can also state your views and clarify some of the salient points that you have in your written submissions. But if you can kindly send that information that you referred to for September 2023.
I think you also requested some details around financial information, Madam Chair, which we'll also provide.
Yes, the evidence, so that we can look at that, especially because it is disputed. Obviously, you know that when matters are disputed, we also need to find out the credibility of the information that you're coming up with, as you are well aware of the challenges when it comes to cost, that the cost information will always be in possession of the company, and it's the commercially sensitive information. So what is it that we need to look into account there? And information that at least is closer to the inquiry, to what we are looking at. And remember that in terms of the Gas Act is the charge for the molecule at this stage. Mr. Lee, you wanted to say something? Oh, sorry. I wanted to just check from Mr. Lee. I will come to you, Mr. Meira. Yeah, on mute, Mr. Lee. Still on mute.
Sorry, Madam Chair, can you hear me now?
Yes, I can.
Sorry. There's nothing more from my side unless you have an additional question for me, Madam Chair.
Nothing else. I just wanted to check in terms of the final remarks if you have anything else.
No, nothing for me. Thank you for your time.
Okay, thank you. Let me go to Mr. Meira.
Madam Chair, firstly, thank you very much for the way in which you conducted our part and for allowing us a little more time to complete what we needed to say. It's much appreciated. We will, as early as possible next week, my attorneys will no doubt, as quickly as we can, get you all this information, and we will send them to you as also the submission of September 2023 under cover of a letter which indicates to you specifically what paragraphs in that submission we direct your attention to, and the context in which we invite you to look at those. But over and above that, unless you have anything further, we thank you for the opportunity to have addressed you.
Thank you. Thank you very much for your time. And thank you, Mr. Human, as well. All right, members, we are now going to take a presentation from, is it from SLG? SLG, I think it's SLG's time now to present. Just want to check, colleagues. All right, it's Mr. Peter Smith to present, as well as the Group CEO of SLG, Mr. Mzi Chokolo. All right, I can't see you clearly, Mr. Chokolo. Try to adjust again so that we can see your face. You are cut. Yeah, that's perfect. Okay, that's good. All right, we would like to then start off then by asking if Mr. Chokolo, you have any objections in taking the oath?
I do not, Madam Chair.
All right, thank you very much. Can you then raise your right hand? Do you solemnly declare that the facts and evidence you're going to provide to this panel today will be the truth and the whole truth?
I do, Madam Chair.
Thank you. Please state your full name as well as your designation at SLG for the record.
My name is Mzi Chokolo. I'm the Group CEO of SLG. Thank you, Madam Chair.
All right, thank you very much. May I also swear in your colleagues if they are going to participate in the presentation? All right, let's go.
Yes, that will be both colleagues of mine, Mr. Peter Smith and Elise Kruger, please.
All right, thank you very much. May I go to Mr. Smith? Mr. Smith, do you have any objection in taking the oath?
Madam Chair, I'm instructed by Webber Wentzel, and I'm from the Johannesburg Bar. I find myself in the same position as Mr. Mayring in that I'm presenting legal submissions rather than evidence. So I hope you understand my decision not to take the oath.
All right, no, I understand. I did not know. Okay, thank you. All right, shall we then go to Ms. Kruger? Madam, do you have any objection in taking the oath?
No objection.
All right, may you please raise your right hand? Do you solemnly declare that the evidence and facts that you're going to provide before this panel today will be the truth and the whole truth?
Indeed, I confirm.
Thank you very much. May you then state your full name and your designation at SLG for the record, please.
I'm Elise Kruger and I'm an independent economist.
Okay, or independent economist, but you are just, or you're representing SLG?
Correct.
Okay, which economic firm are you coming from?
I've got my own consultancy, Carpe Diem Research Services.
Okay, I think that is important, the name of the economic consulting firm that you're coming from. Thank you very much. All right, over to you then, Mr. Chokolo.
Thank you so much, Madam Chair. We do have a presentation that we would use to guide the conversation. And I just wanted to, by way of just an opening remark, indicate the very unique position SLG participate in the engagements today, in that we straddle both aspects of the industry, in that we're both a customer and a supplier of the gas. So we certainly come, hopefully, and will demonstrate this with a view that seeks to consider all the matters that are at play as the regulator is presiding over this current application pertaining to acquisition costs of Sasol Gas in the year FY22 into 2023. Pete, if you can go to the next slide, please. So in doing so, Madam Chair, there's a reminder I'd like to just perhaps share with the gallery, in that there's a very well-established fact, it has been ventilated today in our law, that is a provision to recover efficient and prudently incurred costs, and this is contained in Regulation 4 of the pipe gas regulations. And then furthermore, when one goes to the objects of the Gas Act, Section 2A and B tells us that, amongst others, the Gas Act seeks to promote the orderly development of and investment in the gas industry. Now, clearly, there's a very rich vein of legal precepts that unpacks and engages these. However, it is important for me as a participant in the industry to just really share my understanding and our effectively our existence in this space. And that is a firm understanding that there is certainly a principle of non-prejudice to industry participants contained in these provisions, specifically both traders and suppliers, while protecting, of course, the interests of consumers of gas in the industry. It is therefore an important sort of understanding and consideration in our participation in the value chain. It also seeks to also reiterate that the gas value chain needs to look at everyone's interest. It is a full value chain. It's got suppliers, it's got transporters, it's got traders of gas, and it certainly does also have consumers. So as we mechanize these provisions, it is important, amongst others, to understand and ensure that costs that are incurred are current and that they tend to send pricing signals through the value chain, and that those signals, by and large, need to be the correct pricing signals. Secondly, Chair, that fluctuations in underlying costs are normally passed through in real time. There certainly is a very, very complicated conversation right now that is taking a retrospective look at underlying costs. And this is specifically important for people that are in the trading space, in the value chain, in that how this mechanization of the decisions that are to be made as a result of this conversation or this consideration needs to take that particular issue into consideration, in that there is certainly a limited capability in carrying costs over periods that could spend as long as 2 years before one could recover these from the market. And thirdly, that we need to understand and provide for the impact of cost recovery mechanisms, Chair. Sometimes it is certainly, I don't want to say easy, but it's easy to forget that a cost recovery mechanism has got implications at a coal face. In other words, for me to come in as a trader, go back to my market a few years on to try and recover a cost that pertains to a particular period is more than just that. There is certainly a consideration that in the proverbial sense that shippers sailed in the consumer market to now come a few years later after the fact might create its own complications. And finally, Chair, before I hand over to our capable legal colleagues who will then ventilate the legal precepts, it is important that whatever mechanizations balance the interests of all the role players in the value chain, specifically the actual impact of the decisions that are made, both from a consideration of their contributions to the cost of doing business or cost of sales, amongst others, so to speak. And Chair, in that regard, I'd like to just perhaps leave those few considerations for the regulator to consider in your deliberations over the matter, but hand over to Mr. Peter Smith to take the regulator through our legal views on the considerations that are in front of us today.
Thank you very much. Mr. Smith.
Thank you, Madam Chair. Madam Chair, SLG filed relatively full submissions on Sasol's application, which I believe are before you. In this address, I hope to be brief. I intend to address three main themes that run through those submissions. The first theme I'll deal with is NERSA's 2020 and 2023 maximum price methodologies, and what we say are their implications for Sasol's application. The next, and as a second point, I will turn to Sasol's application. I will deal with the effect of the clawback, if approved to its full extent, on SLG and other Sasol customers. And I will seek to compare those effects with the effect of non-approval of the clawback on Sasol's interests. It's SLG's submission on this score that the approval of the entire clawback amount would have a disproportionate effect on SLG and its customers. And therefore, it follows that SLG submits that the clawback claimed by Sasol first must be reduced by some degree, and my colleague, Ms. Kruger, will address you on the extent to which we submit it should be decreased. And second, the second submission SLG makes is that the clawback should be spread over more than 1 year in order not to disrupt and cause too much volatility in the gas market. The third submission, or the third theme we'd like to address, is SLG's proposal for dealing with price adjustments in the future, and we'll turn to that last. Briefly, before I commence on SLG's presentation, I would just like to say a word with respect to GAS's position, and more particularly its position that the regulator's functus officio and is legally barred from approving any clawback. We don't address that. We don't adopt that position in our submissions. We haven't considered it closely and we make no submissions on it. Our submission and our presentation is done instead on the assumption that the regulator does have the power to impose some degree of clawback, and I'll elaborate on the regulator's powers right now. So turning first to the methodologies, there are two maximum price methodologies which are conceivably relevant to Sasol's application. The first is the 2020 methodology, which was used to determine Sasol's maximum gas price in FY22 and FY23. And the second one is the 2023 methodology, which Sasol now applies to say what should have been their maximum price in FY23. And this was the methodology that came in around about halfway through the relevant period, to which the Sasol's application relates. Madam Chair, the most significant feature about both of these methodologies for present purposes, and this is an important submission, is that neither provide for a retrospective clawback for allegedly under-recovered gas molecule prices. And it's these gas molecule prices and the alleged under-recovery of them which make up almost the entirety of the clawback amount now claimed by Sasol. Sasol's contention, and they repeated it in their oral submissions today, is that the clawback mechanism is in fact provided for in both the 2020 and the 2023 methodologies. They say it's provided for in Section 6 of the 2020 methodology and in Section 5 of the 2023 methodology. I'm constrained to point out that this, unfortunately, is not correct. Both of those sections relate instead to the under-recovery of trading costs, not gas molecule prices. And as I suggested, almost the entirety of Sasol's clawback amount is made up of gas molecule costs, and it's only a negligible portion that's made up of the trading costs. So the important point is these methodologies do not provide for the type of clawback that Sasol now seeks. And notably, NERSA itself has pointed this out in its clawback clarification note, which it issued in January of this year. It says the formula in the 2023 methodology does not include the clawback component, which created confusion in the industry. Now, that's an important point that we emphasize. So the premise of Sasol's application is that the methodologies provide for that clawback. They in fact do not. So Sasol's application is made on an incorrect premise. The methodologies do not provide for the under-recovery of gas molecule costs. They provide for the under-recovery of trading costs instead. The point that follows from this, and this is also important, is that SLG does not suggest that this invariably precludes NERSA from ever applying and approving a clawback. That's not the case, and that's not the way these methodologies operate in an all or nothing fashion. And in this regard, as we do in our submissions, our written submissions, we point the regulator to the Constitutional Court's judgment in NERSA versus the PG group. I'm sure you're very well aware of it. But at paragraph 33 of that judgment, the court says maximum pricing methodology is not law, but rather a guideline made in accordance with empowering legislation. And NERSA accordingly has a discretion not to rigidly apply that methodology if its application would lead to irrational or otherwise unlawful results. So it does not, the fact that the methodologies don't provide for the precise clawback that's now sought doesn't invariably preclude the regulator from granting one. We do say, nonetheless, that the fact that the methodologies don't provide for this clawback has very important implications for how NERSA must make its decision here. First, we say it must be especially wary of approving a clawback since it's not provided for in the methodologies. Second, we say it must do so in the most conservative and constrained fashion as possible. And third, we say that it must do so only in exceptional circumstances. And in this regard, I'd like to point to two considerations which SLG says underpin the approach we say that the regulator must adopt. The first are the decisions of our courts. And I refer to a decision which is in fact referred to in the tariff guideline of Sasol Oil. It's a decision of the SCA, and we refer to it in our submissions. The SCA makes the important point there that if a methodology is adopted or if a policy is adopted in accordance with legislative prescripts and is empowered by legislation and consistent with it, it should only be departed from where there is something exceptional in the case to warrant the departure from that policy. And it makes that point at paragraph 9 of that, paragraph 19 of that judgment. And the reason why the SCA arrives at this conclusion is it's because it's the very purpose of a policy to provide for predictability, certainty, and consistency. And if a policy is wantonly dismissed or easily departed from, then those very important purposes of the policy are lost. So that is why we say a clawback here should only be approved in exceptional circumstances. The second point we rely on is that we say this approach follows from the price regulation principles and procedures set out in Regulation 4 of the piped gas regulations. These principles include the principles of objectivity, fairness, transparency, and predictability. Now, because the clawback now sought by Sasol was not provided for in the methodologies, it's a clawback that could not have been anticipated or predicted by the smaller players in the industry, such as SLG. It's not something that was planned for by these smaller players, and it's not something that their business cases were developed on the basis of. So just to deal with each of those principles briefly, a ready application of a clawback would, we say, not be objective, and that's Regulation 4.3a of the pipe gas regulations, in the sense that it is not based on a systematic methodology applied on a consistent and comparable basis. The second is that we say it would not be fair. That's under sub-regulation B, because the customers have conducted themselves on the basis that the methodologies will be applied, and those methodologies do not provide for the type of clawback envisaged by Sasol and its application. The third is that it would not be transparent in the sense that the principles did not apply during the relevant period and could not have been anticipated. And the fourth point is that to apply a clawback now would not be predictable in accordance with sub-regulation D. The clawback would expose SLG and other customers to consequences that could not have been foreseen. And without predictability, a business's ability to plan and to make informed decisions is affected to a degree. So what follows from these principles? Again, we point out that the clawback is not provided for in the methodologies. We make it clear, though, that that does not invariably prevent NERSA from applying a clawback of the type under its discretion. But what we say follows from this law is the following. First, where NERSA does impose a clawback, it does so pursuant to its discretion and not pursuant to methodology. And second, where it does so, it should exercise its discretion in a way that departs from the methodologies and is contrary to the price regulation principles in the legislation to the least extent possible. And third, we say that NERSA should authorize as small a clawback amount as possible in order not to unsettle the existing expectations of the industry. If I might then turn to the second main heading I'd like to address, and that's turn to Sasol's application. Now, it's been referred to on a few occasions today, and it's a very important decision, and that's the decision of NERSA versus the PG Group in the Constitutional Court. And the court at paragraphs 70 to 72 makes some important guiding comments, I'll call them, as to how NERSA should approach applications before it, and in particular, applications relating to the maximum price charged by Sasol Gas. And the Constitutional Court says here that NERSA is required to consider the interests of all parties when regulating Sasol's maximum price. It says too that NERSA is required to balance the interests between the monopolist, which is Sasol in this case, and the consumers. And it says that NERSA is required to evaluate the economic surplus being created in the pipe gas market and ensure that it is equitably divided between customers and producers. So to summarize the import for the current decision before the regulator, when considering Sasol's clawback application, NERSA is required to weigh two things. On the one side, it's required to weigh Sasol's interests, and on the other side, it is required to weigh the interests of Sasol's customers, including traders and consumers. And it is required to balance these interests in a way that yields a reasonable and a fair conclusion. So turning to that assessment and dealing first with Sasol's interests, there appears to be no dispute, nor could there be, that what Sasol's application is about is what profit margin it should have earned in the relevant period. It's clear that the price it actually charged did in fact cover its costs. So it's not a case where the regulated entity has made a loss or has suffered a loss which has rendered its business unviable. There's no suggestion that that is the case. Now, SLG does not have access to the underlying figures due to Sasol's redactions. However, its attempts to calculate Sasol's profit margin, which my colleague Ms. Kruger will address, yielded the following result. And that's that in the financial year of 2023, Sasol earned a profit margin of around 13.5%. So even where it says it was not recovering all of its costs, it still made a profit of 13.5%. And if it's permitted to recover the entire clawback, that will enable Sasol to earn an effective profit for that period of 30.8%. So those are not insubstantial figures. And I emphasize as a final point in addressing Sasol's interests that there's no suggestion that the failure or the non-adjustment of its price caused it irreparable financial harm or in any way injured the viability of Sasol. In fact, Guas's presentation suggested quite the converse. Weighed against that, we need to consider the interests of SLG and its customers, and by extension, some of Sasol's other customers as well. At paragraph 30 of SLG's submissions, it sets out the impact that the approval of the whole clawback will have if it's granted. SLG says it will have to pass through a majority of these costs to its customers. It says it's unlikely that those customers will be able to weather, or it is unlikely that all of its customers will be able to weather the substantial increase, which amounts to an increase in price of around 26.8%. In the circumstances in which the country finds itself, where industry and the economy is in a fragile state. SLG therefore anticipates that it will lose some sales and customers as a result of the imposition of the full clawback. And it also says that it's very likely that it will have to bear part of the increase if it is unable to pass through, well, that it is unable to pass through its entire, the entire increase to its customers. So in summary, and again, I refer to paragraph 30 of SLG submissions, the combined effect of the loss of custom and reduced margins, SLG says, will have a substantial negative effect on its business. So to reiterate, if the clawback is imposed to the full extent, it will have a substantial negative effect on SLG and its business, and it's not an effect that could have been expected or planned for because of the non-provision and the methodologies for a clawback. Turning then briefly to balancing these interests, on the one side you have Sasol, whose marginal profit is at stake, and I gave you those figures, and there's no suggestion that Sasol's been placed in jeopardy as a result of the non-increase. On the other hand, there's an undeniable substantial impact on SLG's business and that of other small businesses. And that there's obviously a disproportion there, which argues against the acceptance of the whole clawback. SLG's submission, therefore, is that an equitable balancing of the interests, such as is required by the Constitutional Court's judgment, is not achieved by approving the full extent of Sasol's clawback. And SLG says that that would not achieve a reasonable and rational outcome. SLG seeks to adopt a reasonable and pragmatic approach to this, however. So its proposal is twofold in light of this disproportionate burden that it and its customers will have to bear. First, it suggests that rather than refusing the clawback in its entirety, it suggests that the clawback should be reduced. My colleague, Ms. Kruger, will address SLG's submissions on the extent of that reduction. The second proposal SLG makes is that the clawback should be recovered over more than 1 year in order to soften the impact of the price increase on SLG and its customers, and to reduce the potential for volatility in the market that might be created by a dramatic increase in price. SLG submits that this solution would, in fact, more equitably balance the interests of Sasol as the monopolist supplier and its customers, as is required by the Constitutional Court's judgment. If I might then turn to the third issue briefly before my colleague, Ms. Kruger, continues, and that's in relation to SLG's recommendations for the future. SLG submits, and this is borne out by our analysis of the methodologies, that clawbacks on gas molecule costs should be permitted only in the most exceptional cases, and that where they are permitted, they should be approved and implemented in the most conservative fashion possible. The second point is that SLG says clawbacks can in fact be avoided entirely if maximum prices are adjusted on a regular basis. And the 2023 methodology permits for a dynamic adjustment of maximum prices. The proposal in section 4 of the methodology is that prices be reviewed on a 12-month basis, but there is provision for when a licensee's costs change more frequently, that the licensee may charge its cost of gas in the maximum price formula, and there is provision for a more frequent adjustment of the maximum price. SLG would commend this provision to the regulator and suggest that there is a more frequent adjustment of the maximum price, and that maximum prices should indeed be changed on a monthly basis. And there's, of course, precedent for this in the liquid fuels industry, where the petrol price changes are effected on a monthly basis. If I might then hand over to my colleague, Ms. Kruger, to address the numbers.
Thank you very much. We've taken 27 minutes already since we've started the presentation at 12, but I will allow Ms. Kruger to address all of your economic issues that you want to bring to our attention, but just be mindful of the time.
Thank you, Madam Chair. You'll be glad to hear that I've only got one slide and one table to talk you through. So we've done some calculations on Sasol Gas's implied profit in FY22 and FY23. And I would like to talk you through the table. I just quickly want to say or note that we did not have the actual acquisition costs of Sasol, as all of those figures were redacted in both the application and in the consultation document. So we have done our own estimates for the weighted average acquisition cost. So therefore, if you do include the actual numbers, it will not change the principles or the conclusions of this table. It is based indeed on our estimates though. So if you look at the maximum GE charged in FY22, based on the 2020 methodology, the maximum GE of 68.39 Rand is deemed to include acquisition cost of Sasol Gas, a trading cost, and then also an implied profit. Now, we have calculated that implied profit in FY22 at 26.34 Rand per gigajoule, and that's results in an implied profit margin of 38.5%. Now, based on an unchanged GE in FY23, if you do the same calculation based on our estimates of increase in acquisition cost, we've taken Sasol's trading cost as an assumption, you see that the implied profit margin reduced to 9.22 Rand per gigajoule. That results in a profit margin of 13.5%. And if you look at the third line, it's just the differences between those two financial years. Now, we are saying that, it's clear that there has been a profit already, despite the increase in acquisition cost and trading cost. If you look at that reduced profit of 17.12 Rand and you take half of that, which gives you 8.56 Rand per gigajoule, you add that to the profit already made, the 9.22, and you'll end up at an overall profit of 17.78 Rand. That will give you a profit margin of 23.1%, which is quite reasonable in our view. So on the basis of what Peter has also discussed and Mzi's introduction, we are thinking that if the industry can, or let me say Sasol can forfeit half of that profit that they lost, and the industry could do the other half, you already look at a scenario where there's a comfortable profit margin for Sasol. So therefore, we are proposing that Sasol, or that the clawback be considered to be half of what Sasol has asked for, half of the reduction in profit, based obviously on the actual numbers. This is just an illustration, but just to show and to reiterate that it was not a matter of no profit, and it's not a matter of, it's a question of how big the profit margin would be considered to be reasonable. Thank you.
All right, thank you very much. I would like the colleagues to then come in and ask questions of clarity. By show of hands, colleagues, if you have any questions of clarity from the presentation received or made by SLG. Okay, I may then start whilst the colleagues are still busy, maybe thinking about the questions. Let me start then, Mr. Gumede.
Chairperson, thank you. Thank you for the opportunity. I've got two questions. Again, they're just questions for me, just of clarity, and also, and please, can they be taken in that context? I just like to get more information. On the slide that you presented in slide 8, I'm always, we're dealing with an entity here. So Sasol Gas, I would assume, is Sasol Gas is part of a large entity, Sasol Pty Limited listed entity. Now, I always wonder when I look at these information, is it possible to give us, yes, it's your analysis, and if you can share that detailed analysis with us, that shows. Okay, maybe let me phrase it this way: the data that you have in there, I'm just trying to understand. Is it really for just Sasol Gas, and does Sasol Gas only operate in South Africa? Remember, we actually have to. I'm just asking these questions from a novice point of view. That is this only for just Sasol Gas as it operates its assets in South Africa? And Sasol Gas's numbers that you may have, I assume it's Sasol Gas's numbers, the total of Sasol Gas would that only refer to the operations relating to Mozambique and the methane-rich gas, or are there any other costs and revenues perhaps that Sasol may be getting or incurring and getting from other gas operations? If you can just give me those so some kind of understanding on that. Maybe it's a question for Sasol, but because it appears on your slide, if you can assist, if you can. But my question really relates to the question I also asked IGWA SA, that, as you say, you don't think that the Act prohibits NERSA from working out a clawback and charging a clawback or allowing a clawback. But the question from your point of view, who should that clawback be levied on? Should it be levied on the past customers? That is, as an under recovery from those customers. So you look at the invoice that was sent, and you say the invoice that was sent was based on a number X, but that was having worked out the under recovery. Then we should then go back and then revisit those invoices and actually charge those customers the clawback. Is that where the clawback is supposed to be put to? Or are you saying the clawback should then be charged on the future customers? That is to say, the future customers then have to pay for the costs that should have been recovered from people that actually consumed the particular commodity in the past. So who should it be charged to? The past, that is, we revisit the invoices, or should it be charged in the future as an under recovery that then changes the price for the future? Thanks.
Thank you, Mr. Gumede. I do have some questions of clarity as well from my side, just to understand the position that SLG is taking here and what SLG would like the regulator to take into account. I do want to start off with the slide that relates to the profits, or that was showing the profits. And I do take the point that you said that these are not perhaps the actual acquisition costs. Firstly, I would want to find out, where did you get this information, and whether this information is one that it takes into account other businesses, as opposed to the relevant cost information pertaining to the gas molecule and the trading assets of the gas molecule, because that's what we are all about here, because we're not dealing with the tariffs in terms of the legislation. The tariffs will talk to your gas pipelines, distribution, and as well as transmission. But for today, we're talking about Section 21(1)P read with Regulation 4.3 as well as Regulation 4.4, meaning the gas molecule plus then the trading assets that are enabling the molecule to move from point A and point B to point B. So I just want to understand, where did you get this information, and whether that information then excludes other businesses. That's the first thing. I think it's also related slightly to the question posed by my colleague, Mr. Nhlanhla Gumede. The second thing that I want to understand, that slide shows increase in cost, if I'm correct, because you have put the increase in cost. You've got an estimated cost of 56% or something, or 56 rands per kilojoule. I can't remember. Estimated cost, it's about 54. 54, as I assume, per gigajoule. And then you have the price that then is sitting at 68 rands. Remember, this is not the actual. It should be the maximum. So there must be the surplus, so that then Section 22 must then be applied to arrive at the actual price by Sasol, so that it complies with Section 22. So it must cut down and charge people differently based on their quantities. Now, so are you saying that simply because it made that amount of profit margin, that Sasol Gas ought not to have adjusted that maximum price at all, so long as there's that 13.5% that you have there, so long as there was that 13.5%. So even if there's a cost increase from 37 to 54, that Sasol must absorb that cost increase. Is that the way that you are suggesting that the regulator must look into it? Remember, FY22, you said the cost estimate is 37 rands, 60 cents per gigajoule. Now you're saying that for FY23, the cost increased to 54, but the price remained the same. Are you saying that that's an appropriate economic rationale that this business, even having a significant cost increase, looking at your figures, it must absorb such cost increases, and so long as there seem to be 13% profit in that regard? I just want to understand what exactly is SLG saying here. And then there's an issue that is raised with regards to the issue of the Concord judgment, of taking into account the interest. We appreciate that at least Advocate Smith also made mention of those key considerations. I think one that also did not come out is the issue of the surplus that the Constitutional Court referred to say that if you've considered, here's the cost and the surplus to get to the upper bound, not the lower bound of the price. So the upper bound, and then if there's that surplus that seems to be higher than what would be expected, then it be shared equitably. So in this case, where you already have a constant price that was charged for 2 years, despite the adjustment that was allowed, does it mean, therefore, that Sasol must still, share equitably? In what way would it share equitably in these circumstances where the cost have increased? That's the first thing. And in what way does SLG suggest that we then address the issue of prejudice as well as the risk on the part of the supplier, as it is a consideration in terms of that judgment, that we don't only look at customers, but we must also look into the interest of the gas supplier so that there's sustainability in terms of the supply to the gas market. I just want to check how we can deal with that. There's a point that has been made that about Sasol that it has chosen to not implement the adjustment. But I do want to also just find out, because we have received from a number of customers in the market, I suppose maybe also it was a concern from SLG, that, and this is from August of 2022, up until September, because customers received letters suggesting increases. Then the customers came to NERSA, asking NERSA to intervene, and also that the increase seems to be quite excessive. Now, is it therefore accurate to say that Sasol chose not to, because Sasol was insisting, but also it met resistance from the customers as well as from the regulator? So is it true that then Sasol chose not to get the money that it was allowed in the decision to get, and therefore they must see how they come out of that situation? Is it a fair representation of the situation that actually happened? I just want to find out from SLG in that regard, if that's the situation. There's mention also of the retrospective implementation of the clawback. But the clawback in itself, is it not a backward looking in any event? Because remember, when you approve a price, especially if it's the multi-year price, so you would not have all of the economic data. you will also just make sort of assumptions, but the assumptions must also be closer to reality. Then things happen in the market, like the demand shocks that were experienced, as well as the supply, the tightness of supply around the world. So it means the economic data that was used could not, well, it was very different from what was anticipated. So the clawback, when you talk about retrospective, what does that mean? Is it not supposed to be a backward looking in any event? Because it would have been the shortfall. And because of that shortfall, you also need something that you can rely on, like audited financials for the regulator, then to use something that is credible for the regulator to consider that. So what does it mean, therefore, that one cannot consider retrospective clawback? I'm just using the term that was used there, the retrospective clawback, if one can clarify that. Yeah, I think that's the last question. And this is part of what Mr. Chokolot talked about in terms of providing the right signals, pricing signals to the market, and the fact that it is crucial, therefore, that such signals must facilitate investments and entry into the market. And you cited correctly Section 2A of the Gas Act to promote investment in the gas market. Does it mean, therefore, that the prices that are not adjusted and they are constant whilst the cost is increasing significantly? Does it mean that such price adjustment, so such price levels will then send a signal that will enable the regulator, so that will enable or facilitate investment and facilitate entry? Will the regulator be doing a good thing in terms of achieving such objectives of the Act of promoting investments if prices are constant but the cost is going up? Would you say that it is a rational situation that will actually facilitate investment? And lastly, the issue of the impact. The issue of the impact on SLG. SLG, if I recall very well, SLG actually, the price method, in terms of the price methodology, it was it had a very different maximum price level from Sasol Gas. So maybe I must be clarified as to how that is going to affect SLG, because they were using the JKM, the Japan Korea marker price as a benchmark, and therefore there were profits that were added there. And for financial year 2021, it was 151, which is far above the one of Sasol. And then there was also one for 164 that was approved. And all of them were very high compared to this sort of dominant player, which is Sasol. So I'm not understanding in what way, if other players in the market, they had prices that are at 160, others they went to actually 200 per gigajoule, and then the price for Sasol, who's the main supplier, they were well below 100 rands per gigajoule. What does it mean then that they will therefore suffer in this instance if the maximum price was sitting at 68 rands, but theirs was well above that? I just want to understand that aspect. But the last thing is that at the time of the Concord decision, Sasol was classified as a monopolist. I am not sure that in my understanding of economics, especially industrial economics and microeconomics, whether now Sasol is still the monopolist, because we do have other licensees that entered the market. So the market structure, even if the effect is not significant, but the market structure has changed slightly. We've got the likes of Kwande that now brings gas directly from Mozambique and brings it to South Africa. So Sasol, rather than being a monopolist, Sasol is a dominant player rather than it being a monopolist. And we do have others as well that are bringing gas to South Africa. I just wanted to bring that aspect as well, because it's also the information that is there in the market, but also in the regulator, that we're not dealing with a monopolist in this case, but we're dealing with a dominant player. Thank you.
Should we proceed, Madam Chair, with an attempt to respond to the questions? I certainly hope I've captured them all. I did capture a few, and I will certainly start, and to the extent that my colleagues have identified the relevant sections and have left anything out that they need to handle, they will do so. So perhaps the best is to start with the last point that the regulator raises, Madam Chair, that perhaps we are dealing with a dominant firm and that there has been developments in the market, and as such, one expects that to have changed the structure of the market somewhat. It is important to indicate that, yes, albeit that there had been new entrants in the market, as Madam Chair stipulates, for instance, Kwande Gas, the basis on which Sasol was deemed a dominant firm haven't changed, because there has just not been a material volume of gas that has found itself into the market, and as such, hasn't changed the market structure in any meaningful way. Just by way of example, Sasol still is importing to around 160 petajoules of gas into the country, when Kwande only imports 0.5 petajoules. So strictly speaking, therefore, that hasn't really had a material impact in terms of changing the structure of the market. The second point that I'd like to handle is perhaps an issue that might struggle a couple of the questions. It starts with the actual price of Sasol that is in question, and it ties onto the slide that was flagged that showed deemed prices and profits. Is that the 68 Rand in itself was the maximum price as determined by the regulator. And coming out of that was then applied as the actual price to the market. That issue then effectively means the understanding that the 68.39 being a maximum creates an environment where actual prices will be below that, and thereby implying that there is a surplus that is left, is by and large then eradicated by the fact that the 68 became the actual price. And so a conversation that says, but there certainly should already have been the surplus that is being shared, is kind of eradicated by that fact. Then, of course, one wants to deal with the part about the retrospective consideration, and I think, Madam Chair, you also bring into account the part about whether the price signals that we want to be sent through the market are indeed correct in wanting that and I don't want to call it a prejudice, but let's call it a compromise, as we've also in our own numbers shown that there has been a lessening of profits in Sasol Gas in the prevailing period. And the fact that that retrospective view should go uncorrected, how then is that serving the market, one, from a pricing signal point of view? And secondly, that there certainly is an assertion that in the intervening period, there has been an increase in prices in other instances. The Sasol price has always been seen, for starters, as the market price, especially in the context of the 68.39. And as such, when it became apparent that there has been no adjustments of the underlying market price, notwithstanding other mechanisms being in operation from a maximum price point of view, it certainly set the signal of prices being kept in moratorium until a decision is made. So there certainly was some signal that followed that development. Furthermore, is the fact that, and I think it's SOG's stated position, maybe, and perhaps it's important for me to reiterate, and Pete, of course, when you come on, you will also, I don't want to speak on your on your behalf. But the idea is such that in a world where the clawback, certainly there's the legal precept that's been sort of elucidated as to how and when it's applicable. SOG's view is that where there has been harm suffered by Sasol, in the sense that, if there was a loss, for instance, we are certainly not saying that loss need not be covered. As a matter of fact, even in our own calculation that this was not a loss, it was a reduction of profit, we are still effectively supporting a view that says some level of clawback needs to be considered, albeit that its net impact is to shore up the realized profit of the time in question. So I think a view then that says we want to create a world where what's good for the goose is not good for the gander is certainly not what we're saying. And then, of course, there was the mechanization that we can deal with regards to who pays for this clawback. I did touch on the fact that the market hasn't materially changed. Now, it's a question, of course, that's on the table. And it should be a question that is part of the regulator's consideration of the application. That is the fact that if this particular clawback pertains to a particular period, question one around it is, are the current customers of Sasol, who for all intents and purposes are due recipient of the clawback invoices, are they still active customers of Sasol? And if they are, it would therefore make sense that those are the people that the clawback applies to. Secondly, what then becomes of those customers who are now not customers anymore? Does somebody else carry their, let's call it, can with regards to the clawback? As I said, these are considerations that need to form part of the decision, and SOG is certainly not sitting here to dictate how the mechanization of whatever clawback is approved is to be rolled out in the market. And I certainly think that in their application, perhaps Sasol should have perhaps elucidated the how do you take this to market question. I think in discussion is more the period over which this should apply and the level or the magnitude. But there certainly are nuances like then who is to receive the particular, because at the end of the day, it is an invoice. And in conclusion, Madam Chair, there was a part that Madam Chair asked with regards to, for instance, an SOG that is asking for or is putting forth this view that we have on this clawback, in almost creating an impression that we've had and I don't want to call it a hardship, but we are going to suffer from a clawback. But I think that the actual statement made was this will have an impact on smaller players like SOG and consumers. In other words, there were business plans made on particular numbers. There is certainly an activity that would need to be undertaken as to, as I said earlier, how is this clawback in reality mechanized in the market when it arrives? One of the points I made when I made my opening remarks was, for instance, the way it's being proposed currently is that it becomes a cost that requires audited financial statements of the applicant, for instance. In a case where this becomes part of, let's call it, in addition to the acquisition cost, which is real and it's in time. A simple example would be that if I, as a trader, received an invoice for a clawback from Sasol on the 1st of July, 2024, that invoice is due at the end of that month. Whereas if I then need to still carry that invoice through my business for the duration of the year, until at the end of the financial period, we produce financial statements, which we then use as a basis to decide, do we go to market and try to also do our own clawback, or do we live with the impact of this in our business? This is the sort of impact that is being referred to, and not necessarily a question of suffering, so to speak. Madam Chair, Peter, if perhaps there are particular aspects of the questions that you captured that pertain to the legal arguments we made, please assist, and Elise will handle the part about the specifics of the pricing used and the origins of the numbers.
Thank you, Mr. Chokolo. Advocate Smith.
Madam Chair, thank you very much. Mr. Chokolo touched on most of the important issues, so I will just address a few questions where I think submissions need to be made. Please do say whether we are missing anything. I concede I may not have got down every one of the questions perfectly. I'd like to first address just Mr. Gumede's second question, and that's in relation to how this clawback is operationalized. And Mr. Chokolo dealt with that to some extent. And Mr. Gumede asked whether the effect of the clawback is to go to customers who were customers in FY 2023 and require them to pay more. That's not my understanding of what Sasol asks for, and nor would that be possible in practice. It would be what's termed in legalese a retroactive legislation, which is generally frowned upon, and you couldn't upset past contractual relations in that way. So what my understanding of what Sasol asks for is that going forward in future periods, they charge all their customers an additional charge based on the alleged under-recovery during this period. And as Mr. Chokolo said, that's an important consideration, because what that means is that even new customers who were not, in fact, customers during the relevant period, who allegedly paid less than they should have, will be mulcted or penalized by this additional charge. So that's a consideration that needs to be weighed by the regulator when it decides on whether to impose this clawback and to what extent it should be imposed. Madam Chair, if I then might address very briefly some of your questions, and I think Mr. Chokolo dealt with most of them. The second question, you asked whether Sasol should not have adjusted its profit at all. We certainly don't say that by referring to the fact that they earned a 13.50 Rand, I think, profit in the relevant year. We simply say it's a question about how much profit they should earn, and we seek to take a middle road there. We say we don't think they should earn the full extent of what they're claiming in the clawback, but we don't think they should earn the minimum either. We seek to find a reasonable accommodation in the middle, which we say sort of balances equally all parties' interests. If I might then address your third question, which is related to this question, and that's in relation to the Constitutional Court's judgment and this idea of economic surplus. As I understood the question, it's the proposition is framed as follows. With respect to economic surplus, Sasol is entitled to recover its prudently incurred costs. Why then should this eat into the economic surplus that is allocated to it by the methodology? That's the profit margin it is entitled to earn. And Mr. Chokolo made the important point that the economic surplus that's enjoyed by traders and other customers is already eroded to a degree by the fact that Sasol, as a matter of course, charges at the maximum price. But the other important point here is this: we're not in a world where the methodology is simply being applied at the time in question and that the surplus is being allocated. We're in a world where Sasol seeks to claw back some of this surplus 2 years later. In a perfect world, we could go back and allocate this surplus appropriately in terms of the methodology, as is required by Regulation 4.4. However, if we were to do so now, it comes into stark contrast with some of the regulation principles in Regulation 4.3, which require NERSA to make decisions in a fair, objective fashion, to be predictable. So it's SLG's submission here is simply that we cannot reconceptualize ourselves in a world where we back in FY 23. The balancing of interests needs to occur in view of the fact that we are now 2 years later and customers of Sasol are potentially incurring a cost which they could not have predicted or foreseen. Madam Chair, those are my submissions. If there's anything further you'd like addressed, I'm sure you can deal with it after Mrs. Kruger.
Thank you. If I could address the question from Mr. Gumede relating to where the data and also Mrs. Msiti about where the data is coming from. So on Sasol's invoices on a monthly basis, they do publish at the very bottom in fine print the composition of the cost price. So there we managed to start tracking both the methane-rich gas price and also the natural gas price. Unfortunately, we do not have a full set of data, as you know, for some months, particularly July to October 2021, the details suddenly disappeared from invoices. But we also need to do an estimate because we do not know the volume split from Sasol Gas's volume between methane-rich gas and natural gas. So we've used a fixed ratio, methane-rich gas being 14% of total and the remainder natural gas. But that's the existing business of Sasol. It doesn't include any new suppliers or anything like that. It's the existing business, methane-rich gas from Secunda and natural gas from Mozambique. So we've been tracking those two, the two that are supplied to SLG, and that's where we got our numbers from. The weighted average cost there, we have assumed, like I mentioned, the fixed proportions of the two different markets or two different gases that are supplied. But there's no other trading activity. It's only the gas molecule. So our table here only focuses on the gas molecule price in the first, the acquisition cost estimate that you see there. Thank you.
Thank you very much. Any other questions from the? Okay, let me take from Mr. Gumede. Mr. Gumede, please go ahead.
Thank you, Chairperson. Just two quick follow-ups. The first one, based on the slide, I think it's slide 8 from SLG, and it's really just a generic question, and you may choose not to answer it. But I'm just trying to get a feel and understanding that as we make a decision going forward, is that we all know that a return that is commensurate to the risk and of cost that is based on the cost of capital is an allowed regulatory cost, and I don't think SLG is disputing that. I'm just asking that based on the numbers that are presented, that whether they are correct from Sasol's point of view or not, in terms of the implied profit margin there, and therefore I guess one would then have to, from that implied profit margin, one would actually have to calculate the actual return, I guess the return on equity or whatever. There's a number there. What you're saying is that you are saying, based on the FY 2022, financial year 2022, there is a number that is implied of 38%. But what you are then proposing is that we are saying that you're not saying that that number, sorry, the implied number of 13.5% perhaps is the appropriate one, and we are saying perhaps Sasol should consider a reduced number that will yield an implied profit of 23%. I guess my question I'm asking, are you saying that number, although in terms of the regulatory costs, a profit is allowed, it should be allowed, are you saying perhaps that maybe a number close to that 38% would be too high and not reflective of the risks that are associated with this business, and that a number close to 23% would actually be an appropriate number? I'm hoping my question is clear. I mean, I'm on the basis that we all agree that in terms of tariffs, a return is allowed, and a return comes from profits. So are you then saying that all we are saying is that the number close to 38% is just not appropriate, that you are saying that perhaps a number close to 23% would be more appropriate? So that's the first question I'm asking, and I'm really hoping that Ms. Kruger will be able to assist me with this. The second question that I have is more generic, it's more general in nature. And it says, we all know of this impending cliff in 2026. and I'm talking about the actual supply cliff, which will probably come, I would assume, with a perhaps not a cliff, but more a serious rise in the prices of gas if the cheaper sources of gas are no longer available and industry still needs gas, will need to go to other sources of gas. Is that I'm just asking that for a regulator to consider, if we're looking at sustainability and also price predictability, how do you think the regulator should look at the current price projections? And do we believe that okay, I guess what I'm asking is, how do we see ourselves smoothing out these likely price increases that might emerge? Maybe I'm wrong again. I would like to be corrected on that. That might emerge with that price cliff. But if the price is with that supply cliff, if that supply cliff becomes real, and therefore the projected prices will probably have to go up, how do you think the regulator should manage that going forward? I'm also hoping that Ms. Kruger, you'll be able to assist us with that, and if you can, of course, and correct me if I'm wrong. But I'm also assuming that the question I'm asking is clear. Thanks.
You are on mute, Ms. Kruger, please. Oh, sorry.
Sorry, Madam Chair. If I may, and if Ms. Kruger wants to elucidate, she's very welcome to do so. But Mr. Gumere's question pertains to a trader having to make a determination as to what another trader is entitled to from a profit. I mean, the question, yes, is general in its sense, and it's clear. But if I may be excused, that it is not our place to really dictate what is acceptable. Ours is merely to proposition a view coming from where we are in the market. So that is really the part where we say we will leave that to the regulator to make that determination, Madam Chair, if I may. I do then want to perhaps transition to the next question that deals with, in the event that we certainly are running, and it's not an event, it's actually in the eventuality that the gas runs out and the new sources create a different pricing regime, which is expected to be substantially higher than the kind of regime that we're in. Is the expectation then that those prices are not to be accepted? I think we are on record effectively saying that where there is a direct link of underlying prices or costs to the availability of gas and the resultant prices, there certainly is no qualms about paying or engaging with the market on those costs, number one. Number two is we certainly will be talking about a world that is forthcoming, which enables pre-planning in anticipation of that world and getting ready for it and making sure that the underlying prices are certainly sent throughout the value chain, including into the final products that are produced out of, let's call it, the substantially more expensive gas. That is the orderly development world that certainly is with the benefit of foresight we can get ready for, we can prepare for, and we certainly stand confident that the gas industry as a whole would have to make the requisite adjustments to live with that reality. So it's really not a question of today, meaning that the reality of tomorrow is always going to be framed in today's lens. It certainly wouldn't, and the conversations we're having are very clear that that world will find a place in the gas industry. but it will be the reality of tomorrow.
If I might just make some very brief submissions on Mr. Gumede's first question, and Mr. Gumede, you're quite right to suggest that it is not our position that Sasol shouldn't make a profit and that it shouldn't make a profit commensurate with its risk. But what we do say is that the requirement the principle in Regulation 4.4 that a trader or licensee should make a profit commensurate with its risk doesn't guarantee a particular level of profit for all time. In fact, the requirement imports a fair degree of discretion to the regulator in how to determine what is an appropriate and commensurate degree of profit for the risk. And as we all know, in terms of valuations and finance people and economists, different people will come up with a whole range of what they conceive of as appropriate compensation for the risk that a particular business undertakes. So what we do in our submissions is we simply make a proposal in this regard. We say that in the circumstances of this case in particular, an appropriate profit commensurate with Sasol's risk is not the full extent of the clawback, the plus 30% margin. We say it's more in the region of 20%, as Ms. Kruger said. The last submission I'd like to make is that the provision we're dealing with here, the price regulation principle, this principle that a licensee should ordinarily make a profit commensurate with its risk, it is but one principle in Regulation 4 of the piped gas regulations. And in the circumstances of this case, where Sasol asks for a clawback a few years later, it comes into friction with, and it needs to be weighed against a number of the other principles which are set out in, for instance, Regulation 4.3, in that the regulator must make decisions which are fair, transparent, predictable, objective, and the like. And we've already made submissions on the fact that those principles need to constrain how the regulator makes its decision in this case. Those are my submissions.
Is there anything else so that we can then move on, Mr. Chokolo?
Not from our side, Madam Chair. Thank you.
All right, thank you very much. We then thank SLG for its presentation and for clarifying the questions that were posed by the members of the panel. Thank you very much. We are now moving to the applicant to make its reply on the issues that were raised. It's not the entire presentation, but to make sure that all of the critical legal issues that were raised, as well as issues of implementation and impact, all of those issues, if Sasol could please touch on those in its reply. Thank you.
Yes, Madam Chair, in the interest of time, we will focus on some key issues that were raised in the two other presentations and the discussion that followed. And then in the last instance, as was discussed earlier in the hearing as well, with regards to the unaccounted for gas issue, as well as the question about hedging of gas prices, we would make some further written submission to the regulator on an expeditious basis after the conclusion of the hearing. I think coming back to the key points that we just quickly want to touch on, I think the first one that we want to highlight is the unfortunate jumping between a reference to the actual licensed entity that is approaching the regulator with a particular application for approval and a general reference to Sasol and Sasol's broader gas business or the entire value chain. The business structure and the regulatory structure within which we operate have to be very clearly understood for purposes of the process that the regulator is currently engaged in. The Gas Act particularly for the licensee and the part of the business of the licensee that it is approaching the regulator, is the trading business. And trading in terms of the Gas Act is defined as the purchase and sale of gas as a commodity. And in that regard, the Sasol Gas Proprietary Limited is the license holder engaging in the purchase of gas and the sale of gas in the South African market, and it is related to that business activity that the particular jurisdiction of the regulator applies in this particular matter. The business structure then further includes the long-term supply agreements to which this trading company is a party. And as we've indicated earlier in our presentation, there are two such procurement areas. The one is the natural gas that is imported from Mozambique. Those agreements were concluded around about 2000, and the basis on which the price for that price is determined was included in that agreement based on the approval of another regulator to which the activities within that jurisdiction is subject to. And the structure of those price provisions is that there was a base price agreed, and that price then adjusts on a monthly basis over time. Sometimes the price goes up and sometimes the price goes down. And similarly, the methane rich acquisition agreement has a similar long-term nature. Again, there's a base price agreed in that agreement, and then there is an indexing formula by which that price moves over time. And the combination of those two procurement arrangements then basically determines the weighted average cost of acquisition for the trading licensee, whose maximum prices are regulated by the regulator in terms of Section 4G and Section 21(1)(p), to which I referred in my presentation as well. When one then delves a little bit into that legal framework, and you ask yourself, as Madam Chair has rightly done, to see and ask, where is the legal basis for the clawback which the licensee has put before the regulator for consideration and approval? Then that legal framework, as I said, starts with Section 4G, which says that when approving maximum prices in terms of Section 21(1)(p), it will do so in the prescribed manner. The prescribed manner is then set out by taking into account the Gas Act, its objectives, the particular language of Section 21(1)(p) itself, but then also the regulations that were promulgated in terms of the Gas Act, and it's in specifically Regulation 4.3 and Regulation 4.4, which that price regulation and how the prescribed manner in which that price regulation shall take place is then set out. And the combination of those two regulatory provisions provides that it should be done by the regulator in on the basis of a consistent methodology. And in order to achieve that purpose, the regulator then adopted and promulgated the maximum price methodologies and also the tariff guideline, which have an interaction with each other, as we've pointed out, as a result of the reference in the methodology to certain aspects of the tariff guideline, which is also taken into account when the maximum price is determined. And one of the principles which is then put on the table in that regard is this concept of a clawback in circumstances where a particular approval was issued by the regulator in respect of a specific time period, and if as a result of circumstances changing, the basis on which that approval was given or made then changed. Now, in the case of the period FY22 and FY23, we find ourselves in a situation where, due to the circumstances that we've described, such a change did in fact take place. The current environment in which we find ourselves under the new methodology and the most recent price applications cater for dealing with such changes in the underlying acquisition cost by having more frequent and periodical adjustments of the maximum price. That was not the case in the context of the 2021 national maximum price decision, and as a result of the circumstances that we've discussed earlier as well, and the directive that was ultimately issued, when Sasol actually did attempt to implement a price under the 273 maximum price yielded by the adjustment formula in the 2021 maximum price decision, we ended up in a situation that we were prevented from and precluded from adjusting the price, and hence the price remained the same in the FY23 period. In the methodology and the guidelines to which I refer, the concept of a clawback is described as indicating that that is a forward-looking concept that is taken into account by the regulator when a subsequent decision is taken in order to cater for a historic change that took place. The intention is not to retrospectively go back, change the prices that applied historically, or to go back and identify the particular customers that paid a different price in a historical scenario. The concept, as described in the clawback description in the tariff guidelines, is forward-looking. It basically is a decision that the regulator takes, and from that point onwards, the clawback is either incorporated in the new price decision or as suggested by the regulator in its own interpretation of the legal framework and the methodology in case as a separate clawback looking forward. And it's on that basis that the application is put before the regulator. And therefore, with all due respect, the whole argument about functus officio doesn't come into play in this particular case, because this is not a request or an application to retrospectively go back or to make an amendment by the regulator to a decision that previously existed. Even though that decision had not been overturned, the time at which and for which that particular maximum price decision applied came to an end at the end of 30 June 2023, and we now find ourselves in a situation where we are trying to address the circumstances that occurred in that time, and in the language of the regulator, we are addressing the cost that wasn't catered for. I think lastly, I just want to make one or two comments about the concept of the equitable sharing of the surplus value as contemplated by the Constitutional Court. I think the first point that I'd like to highlight is that equitable sharing contemplated by the Constitutional Court, it takes place, as was argued earlier, at the time when the maximum price is determined by the regulator, and therefore in the revised methodology environment where the applicant finds itself after the 2019 decision by the Constitutional Court and the adoption by the regulator of the subsequent methodologies, we find ourselves in a situation that at the point where the regulator determines the maximum price, the regulator had already taken into account the equitable sharing of that surplus value, and that obviously limits the ability of the licensee to then apply a price that is materially below that level. Having said that, in respect of particularly the FY23 time period, where we are now approaching the regulator and we're requesting the regulator to approve the recovery of the cost that the licensee faced in that period. At this point in time, the way that Sasol Gas has approached this application is that we have absolutely confined the application to the actual cost increase that the licensed entity faced. And as the regulator has also pointed out in the reasons for decision in the October 2023 decision, that cost comprises of two parts. The one is the acquisition cost that the licensee pays for acquiring the gas molecules. And insofar as the operating cost and the capital cost of the trader has changed over that period of time, that obviously is then catered for and is calculated as part of the trading cost element, which forms part of the clawback that the licensee is then requesting the regulator to approve. To disregard, and we submit that for if the regulator were to disregard the acquisition cost, it would not be approaching the regulation of the price in this question in line with the principles laid down in the Constitutional Court decision, where the regulator was then particularly instructed to have due regard to the cost of what was in that decision termed as the monopolist, and which currently at least is a dominant firm as the applicant sits before the regulator. So, Madam Chair, those are the high level points that I just wanted to highlight and deal with in assistance to the panel when considering this application. As I indicated with regards to the questions about clarity around unaccounted for gas and whether hedging of gas prices, because they are linked to indexation to oil derivatives and the like, which have exchange rate impacts as well. That is a question that we will then provide further detail on after the hearing. I don't know, Dr. Masangane, I don't know if there's anything that you would like to add to that.
I would like to. I'm not necessarily stopping Dr. Masangane, but I do want to adjourn the hearing at now 1:30, because we were due to at least finish before 12 o'clock. And I am also taking that offer to clarify the issues that were asked by the parties in writing, and we allow for 7 days, just like we have done with the other applicants here, so that some of these issues, which are not currently in the papers, some of them, because you've made your application, then there were answers provided by the stakeholders. Now you've got to reply to some of the issues that arose from the answers that came from the stakeholders. So we'd like them to give you 7 days to touch on those. The reason being that the issue of the legal status of the clawback has been questioned. It's not something that we can just not get written submissions from Sasol with regards to that. We hear your high-level response, but we do want to get your legal submissions on that, because it's not just a question of stating that it is allowed. I think SLG made it clear that it doesn't appear in the methodology, so you do have to respond to that specifically. And the other thing is that from IGWASA's side, they are stating that it is flawed because it is tantamount to NERSA revisiting its decision. So it's important that, because those are legal submissions that were made, that you then reply to such legal submissions, even though you've already just at a high level. You've touched on that, and not only that, then there's a concern with regards to who's going to then be allowed to pay this clawback in terms of customers at the time, or existing or future customers. So that clarity, you just need to touch on it. Also, because not only that it was raised by SLG, but it was raised in a way by IGWASA by mentioning the issue of surcharge. They characterize it as surcharge that will then be charged on customers. So you do have to address us on that issue of surcharge, which you haven't done so in your reply, so that we know how do we take each point raised by stakeholders into consideration and look at it carefully and see what responses were provided by the applicant and what does the regulator say with regard to our own independent assessment. So those are some of the issues that were actually raised, including the hedging as well as unaccounted for gas and those legal arguments that were raised. And I think also it's important that you furnish the regulator, if that, because I haven't looked at myself to work on the matter closely as the team has done, because obviously at the end we are decision makers and they have to adjudicate over the application itself. The issue of the cost here, it comes from both of the companies that presented today, although they've also admitted that it might not be accurate information when it comes to acquisition cost of gas. But I think it's important that when Sasol responds to that, it provides us with sufficient information to the regulator to be able to see these kind of calculations done by IGWASA as well as the calculations done by SLG, and compare then whether such assumptions or estimates that these parties have made, it's accurate cost data that pertains to the relevant business or relevant line of commerce that is the subject of the application. I think that becomes important. If you can make sure that you do respond to that. And I think Mr. Lee already also stated that it is also the request for the regulator to pursue that angle of due diligence in scrutinizing the total cost for Sasol. So we do want Sasol to then furnish us with some of that information within 7 days, as we need to look carefully into this and take every point raised into consideration. Dr. Masagari, do you want to say just one last thing to close?
One statement, Chair. If one has listened to the whole engagement today, you realize that the delays in making a decision are bringing in a lot of complexity, a lot of uncertainty to the industry. So we can only plead with the regulator that we should make a decision on this matter so that whatever decision it is, it can be applied on the 1st of July 2024. With that, we will make a commitment on our side to give you the written submission within the 7 days. Thank you very much, Chair.
Thank you very much. We will definitely, once information is before us and it is sufficient to enable us to make an informed decision that we can stand up anytime, we will definitely make a decision. It's something that we don't shy away from. However, it is also important that we don't make decisions in haste, and also when we do not have sufficient information, because that will also pose a risk to this body. If this regulator also feels that there's also another step that it needs to fulfill so that it is comfortable with the final decision, the regulator will take a decision to say there are these aspects that we believe must still enable us to take another round and look at them carefully. So that is still within the discretion of the regulator to protect its decisions. All right, but we do take note of what you are saying. Thank you very much.
Thanks.
All right, thank you very much, Sasol, for the reply. We look forward then to the information you will provide within 7 days from today. We also look forward to IGWASA to provide us with the information that they promised also within 7 days. I'm not sure about SLG if there was any outstanding information that SLG needed to provide to the regulator as we asked for clarification. But I would like to thank everyone, the observers as well as the presenters today, for coming forward and assisting the regulator in looking carefully at the application that is before us. And the regulator will await those clarification, the documents to clarify, and then we will inform the industry when we are ready to take a decision, because this is not a light matter, and since also it involves not just legal issues but also economic issues. So we will take all of that into consideration. Thank you very much. I would like to thank also the members of the energy regulator who are members of the pipe gas subcommittee for attending this hearing and for also assisting in asking relevant questions so that it is easier when we all discuss this matter before we take a decision. The hearing is now adjourned, and we will take a decision once we are ready to take a decision and let the industry know when that decision will be taken when we publish the agenda for the meetings. Thank you very much, everyone.
Thanks, Chairperson and fellow panelists and everyone in attendance. Cheers.
Thank you.
Members and public.
Thank you.